Actually, will be having a wide repercussions on our way we practice, what we practice, and how we practice. And it is very essential that we understand these judgments threadbare. There have been number of meetings, but they are all webinars, and we only listen to the speaker and we don't interact with the speaker. So study group is a form with the intention that we have in-depth study, we interact with the speakers, we interact among ourselves and come to the conclusion as to what is required to be done, how it is required to be, because we are all practicing as an IP. Some of us are practicing as a lawyer, but basically we are all practicing as an IP. And what precaution we take, what safety measure we built in, how we select the case, what we do, how we interact with the COC, because our independence with the COC is very clearly established now. And independence with all the stakeholders, resolution applicant or other, howsoever the big or small the case might be, it is very important to keep our independence, to do the process, to follow the process, because in this judgment we have learned that even if some lacuna here and there, the entire process will be back to square one. It will be zero again. And the judgment is one thing. Now, what other regulatory measures or IBBI will take disciplinary measure, that is other thing. That we cannot discuss as on now. So, to understand the case better and understand the case from all the aspects, we have invited three leading personality, one from bank, one from law firm, and one our own member, Mr. Udayraj Patwardhan. And we have requested them to take up the other decision of National Spot Exchange, which was delivered on 15th, I think, 2 days back only. They have agreed, all of them have agreed to do so. With these few words, I request Sarah to take over and take it. Hey, introduction pehle karne ka?
So I request Sudhaji to introduce the speaker today.
Good morning, all. We have amongst us Mr. Rajkumar Bansal as the first speaker. He is a fellow chartered accountant, and he has had a career in banking, a banker for 33 years, which includes 8 years as executive director of IDBI Bank, multifaceted experience in the banks across all sectors, including corporate banking, project appraisal, CDR, retail and international banking. And after his banking stint, he was associated as managing director and CEO of Edelweiss Asset Reconstruction Company, which we all know is the leading ARC of India. Welcome you, sir. Then we have another leading personality with us, Mr. Ajay Shah, who is a partner at DSK Legal and has expertise in the restructuring and insolvency, mergers and acquisitions, banking and finance. He has done his law degree from ILS Law College, Pune. His advice is sought for legal and commercial issues pertaining to transactions in the energy and infrastructure projects, particularly in the railway sector. He has various publications to his credit, like in the Economic Times, Mint, Bloomberg, Quint, and on the websites. He also gives lectures regularly at the University of Pune, at ICAI, at the Xavier's Institute of Management. We are indeed privileged to have you here.
Thank you.
Also, we have our own Mr. Udayraj Patwardhan, who will be taking us through the learning from the two case laws, Supreme Court judgments. And he is specifically requested not to give me a formal introduction, but few lines of surface about him. He is originally from Nasik, and after becoming IB, he has made Bombay, is now settled in Bombay. And he has been handling insolvency matters across India, and presently is handling one of very large case of Lavasa, amongst others. This itself is sufficient to introduce him. And I request all to give the speaker a warm welcome.
Chairman WRC. Hello,
We welcome our chairman, madam, and treasurer of WRC for coming. First of all, whatever we are organizing here are all with the blessings of these all three people, and they are giving very good support for this and encouraging for this. And now I request them to
So,
say few words.
Before final start, there's no blessing. In fact, they all are much senior than us, and it is, because of them, this entire setup of IBC is going on. So it is other way around. We are thankful for, making this IBC group live and taking so much interest and calling all such respected speakers over here. And I think that is the fantastic job. And those who are wanting to learn IBC, for them, this is a real platform. So thanks are due to all of you, like, entire core committee. I'll request first our treasurer, CA Fanil Bhai from Ahmedabad, talk.
Thank you, Chairman, sir. Thank you, sir. For me, IBC is like not my cup of tea. So I have nothing more to say, but I'll just say that you all are elite people who are getting this opportunity to share this knowledge. So like if something we can do that, whatever discussions you do here, if that can be minutized in a formal way, and if that can be shared to other public at large, those who are not participating, and they can also take the benefit of this deliberations which are taking place here, then I think so that it may add more value to others who are not joining this particular event. So just with that small suggestion, I would request Gina ma'am.
So Fanil Bhai, why don't you develop some tool and give it to us through AI? We start, moment the meeting starts, we start that, and then, we can summarize that and put it into the group.
Yeah.
That today these are the discussions which have happened. He's a man of AI, speaker on AI throughout India. So recording anyway is happening.
Yeah,
and maybe then
I'll tell the tech. Yeah, tool is already there. I'm using. Yeah, I just missed on it. I'll tell the one who is organizing this Zoom everything whatever you discuss and deliberate here, they'll be automatically recorded. Take a note of that, and then just what our role will be. Just we need to give a legal and a formal look to that particular note which is with
that sir,
Yes.
anyone will do.
Sure.
I mean, we can share the rough note and then they can modify and put it, so the people who are missing, not coming on, that will have sort of a library value. This was discussed, in one of the
At
meetings.
any time, they can refer to those points whenever required.
Apart from it, sir, Fanil, you have come out with your own AI tool. I think which will,
this Monday tool is this only OTA.ai.
that tool, what Fanil has launched, will be also helpful to IPs, because it's a workflow management tool where whatever is written will get converted into diagrammatic representation. So it's an excellent tool that he has prepared, which will be, and again, it is a freebie. So it will be very much useful to all RPs. So down the line, probably all RPs, because that tool will help to explain the COCs and all. By using your tool, it will be a lot of help will be there to all the RPs.
Sure.
The actual demo should be given. Just preparing the tool and
Sir, उसका बहुत अच्छा है.
PDF में सारा steps सब कुछ
Very
easy to use.
So yes,
some
maybe
action
we
to
can-
get
He is around today also.
Give half an hour, 1 hour for presentation and
Telling you, keeping on that.
Sure.
or in next meeting we will, whenever he is here, we will call him for half an hour, 1 hour demo of that tool.
इसके लिए पूरा चाहिए होगा ये के लिए ना तो that is very
So
relevant.
frankly, we follow a protocol, and
Yes.
none of the RCM or office bearer will lead the study group. But informally, yes, he can share the tool and all those things, it can happen, but we don't want to break that protocol of WIRC by telling an RCM. Otherwise, कल क्या होगा? आप लोग कोई आओगे नहीं, हम ही सब जगह पे जा जाके lecture देंगे सारे study groups में. So we are following that strict protocol. So he cannot be a speaker, but in one of your meeting he can come and he can come informally and share some tool. That is fine, basically. But we don't want to send a message that okay, there was a AI speech by him at study group. That we don't want to do.
Because unless it is demonstrated and unless it is practically shown, for us it is those who are above 60. For us, it is very difficult to see.
Appreciate. He will be there, but no formal announcement of him as a speaker will go anywhere. You organize one meeting and you keep last 1 hour where we know that okay, Fenil Bhai will be there. He will talk about AI. That's the practical way out of utilizing his skills.
You got it.
The implementation part.
Only 1 point, CE credit.
So the point which we discussed in the first meeting, I have already spoken to a couple of people over there. Let's give some time, let them come back. Then we start a formal process. Otherwise, what will happen? We'll just write a letter and instead of that, we said that first let's talk informally to them, and if we are able to get it done, then sending a letter will be a one day's job. Fair. So, Dilman.
So, yes, the credit goes to all core committee of IBC study group for making it a point and inviting Rajkumar Bansal sir and Ajay Shah sir with Uday Raj sir, who is also one of the core group members. And yes, the Supreme Court ruling has, challenged the entire IBC code. So let us, understand that what are the implications and looking forward for your collective involvement for upcoming programs. So over to you, sir.
Thank you. So you were there in IDBI, if I'm not wrong, in 2001. So, coincidentally, sir may not remember, but I was doing IDBI finalization from KKC. I was working there on a retainership basis, and I still remember a lengthy discussion. You remember? Great. So I remember a lengthy discussion, but so transparent. Perhaps you were CFO, sir? And so transparent discussion. Probably, if I recollect, morning we started, and it might have gone till evening. And there was certain account where IDBI had special approval of Reserve Bank of India of not classifying them as an NPA, and there was a topic of discussion that day, if you recollect, sir. And of course, the finalization, balance sheet part, the other MOC, this, that, but I still recollect the entire meeting, and usually we see the people in bank will resist saying that ye mat karo, ye mat do, ye disclosure mat do, ye NPA mat karo. But a very positive person in terms of Bansal sir, and I still remember that whatever he will first understand, and wherever if there is something which is to be given as a disclosure, he will say, give a disclosure, give this note, and moment we give him some draft note, he will see broadly what is happening and he will instantly approve. It's not that he will go and do some trinkling changes. I mean, a very positive personality in his working in IDBI I had seen, and that is an impression which I carried. Of course, post that I did not had an opportunity of meeting or talking to him, but I still remember it was somewhere in 2001. In those days, almost around 23, 24 years back, had an opportunity of working with him. And of course, with his vast knowledge, with his experience post IDBI at Edelweiss also, I think we all know he's one of the such person who is thorough professional, having tremendous knowledge on the entire banking sector, be it the current topic or whatever topic. You give him a topic, he'll able to talk, and that for sure I know a person like him is here. We are all fortunate to have him here and listen from him, such a person. And sir, this is a study group meeting, and you are kind to come in a study group meeting. We will love to invite you in one of the conference on NBFC. We are yesterday we were discussing about one of the conference in NBFC, and we will request and love to invite you even in that conference. And of course, like Fenil Bhai, I am also absolutely zero on this topic of IP or IBC. But nonetheless, that's one of the thought in mind that today or tomorrow I'll also come and learn that here. With that, thanking each one of you. I mean, without further ado, we request you to start. We will also proceed for some other program which are happening at the ground floor auditorium. Also, Jayesh Bhai has got one talk on Bhagyo where he is going to share his journey of transforming from a general practitioner to the current practice of IP. So that also we have to start. We thought we'll come here, greet all of you. That was the whole intention. So thank you so much everyone on Saturday morning. To see all of you in a large number is itself is a pleasure. So thank you, and please keep doing good work in the area of IBC. And yes, whatever pending agenda is there, which Jayesh Bhai once again reminded, we will definitely work upon that. We were trying that moment we initiate some work, it should get completed. That was the whole intention. So nonetheless, we will come back to you and we will definitely work something on that. And let's try and positively try and conclude that part of CPE also. With this, thank you so much, and over to the learned speakers.
Thank you. Thank you. Thank you.
Thank you.
Thank you.
Thanks, sir.
Thank you.
Thank you.
Thanks, sir. Thank you.
Thank you. So let us proceed now. So normally, I remember in 2017-18, wherever we listen to a Supreme Court judgment, we used to be very elated about having found some direction to move forward in a particular way. And we have had excellent judgments that guided us, not only the professionals, but all of the ecosystem of insolvency that has brought us to this present stage. Many judgments prompted government to change law, add new regulations, etc. And now with recent two judgments of Supreme Court, one in the matter of Ocean Power and Steel Limited and other in the matter of National Spot Exchange Limited, we as professionals, all the stakeholders are discussing this particular issue in multiple forums, multiple webinars. I have attended at least 10 different webinars and seminars in last 15 days, and the number of opinions that were expressed were more than number of people. So if 100 people are there, the opinions are 110. That is the situation at present. So what we thought that let us sit together and have a forward-looking discussion, because what has happened, and there will be opinions about the judgment, and yes, no, should have been, could have been, and all that. Of course, that is open for discussion. But as a community who is directly involved in the process, we are required to be forward-looking, taking care of what has been done accidentally, deliberately. We don't want to comment, but we have to be forward-looking. So with this brief background, I request Rajkumar Bansalji just to take it forward. We have a structure which has been created. So for 30 minutes, he is going to deliberate. Then 30 minutes, Mr. Shaw will deliberate. Then I will present my view about take home for resolution professionals. And then we will go forward to discussions, etc., questions from members. Then we will move to the other part about MPID and IBC and what is the way forward, etc. So this is the structure we have developed. It have an hour slots each, so that we don't feel bothered too much about what we are studying. So we have to be open about it. Any questions people have? If the members, speakers allow, you can ask them. If they would suggest at the end of the speech, then we can have it in a separate session which will be moderated by Mr. Mehta.
Uday, I would suggest let the speaker have the say.
Yes.
If the intervention is there between, they will also lose the
Yes.
link,
We will.
and we will not be able to complete on time. So let the speaker have their say, and then we will take the questions. Everyone who has a question, kindly note and pad is there. Kindly make a note of that question, what question you want to raise. At the end of the session, we will have that questions.
We already have a time slot for that.
So that would be a bit better way instead of disturbing the floor. Talk.
Bansal, over to you.
Thank you, Garajji, and good morning to everyone. I feel honored to come here. And here also I have come in where see some of the programs. I'm a member of the institute, so I have a right to come here. I think as Peraz was saying, a lot of discussion has been going on this topic, and two seminars I have also addressed. One was from municipal and one was from our own ICI. So somehow this judgment and the next judgment also, which we are going to discuss, and plus two earlier judgments in Vidarbha and Rainbow. I think unfortunate by Supreme Court, but I can't say that. Both were that time slightly took IBC backwards, and they were also given by a judge who was just going to retire. These also have been given by the judge who just retired actually already. Now, you know, when IBC was started, I was some way involved with that whole system. And that time, there was a clear understanding with the Supreme Court also that these are economic laws and we have to implement it in time bound manner. Any issue, that's why it's only a 3-layer system, unlike some of the other legal systems in the country where it could be 10 layers. The NCLT enclared the idea was to expedite the whole thing and then conclude the process within time. And there was an understanding which was reached at that time, indirectly, I would say, that anything comes to Supreme Court, they will not take more than 2 to 3 months to decide. So same thing happened in Binani. In fact, most of the accounts which went to Supreme Court initially, I had handled all. Binani, we were the lead as Edelweiss ARC, and SR Steel went. And both the judgments were given very quick. Binani was given almost like within 10, 15. SR was also 3 months. Being so complicated also. Even then, that was the idea. That is how the economic law should work. A transaction, if it is found by the courts that it is not complying with the law or it is illegal in some ways, you can't say that transaction, you reverse the transaction. And that is how the equity market also works, capital market also works. Stock trade has happened. Have you seen that? Very rarely, I mean, rarest of the rare that you say that transaction itself is cancelled. You can penalize. You lay with the penalty, you pass the discharge order, whatever you do. So economies laws have to work like that with a certainty and with a timeline. Supreme Court itself, this case itself has gone to Supreme Court earlier in Bhushan Power. And that time, Supreme Court has not granted any stay on the implementation of the plan. If that was the case, it should have been done at that point of time. You allowed the implementation when the case has gone to Supreme Court. And now after 5 years, so you mean to say judiciary can take 5 years while we are supposed to decide within 360 days, everything, including the law, including the legal challenges. 30 includes that also, right? Otherwise, it's 270 days. If you have to really follow, so I was just listening last time, so it can be a very positive judgment if it forces all of us. All of us means all the parties involved in the system to implement every plan within 330. And otherwise, you go for liquidation. Today, if I look at the status of the IBC cases, and thanks to all of us are a party to delay the whole process now and spoil the whole. Then 90% cases will go for liquidation. 90% or either I should say, if I just make an extreme statement, 100%. Because any plan, if you analyze the data also, the cases which are not completed 270 days are those which have just started. Otherwise, wherever the plan has come, I think every case would have crossed 330 days nowadays. Because so many cases are filed, so many applications are filed, IAs are filed. So who are the challengers, let's say? Even in Bhushan case, if you really see, each plan technically is challenged, starting from Synergy Dure, which was the first case, and starting from first major case, which was Binani Cement. So who are the challengers? One can be typically the old promoter, which that's why Section 29A was also introduced to discourage those guys. Secondly, the person who has lost the bid, the bidder. So the low, not, I mean, I would say unsuccessful RA, if I use the language IBC. Third, typically will be a financial creditor fighting amongst ourselves, either an FC or an OC. Operational creditor can also be there. And the fourth will be sometime labor, sometime employees, and but the biggest today's time, the biggest has become after rainbow paper to judgment, certainly more. That are the statutory authorities who don't even file the claim within 330 days, file the claim after 5 years, and then still expect that their claim should be admitted in full, and now they should get the full money after rainbow and after jet railway judgment. So I have seen now the PF authorities especially have become too active and they behave as if they are the super god. So nothing can be done against them. And their dues are full, including panel interest. So sometimes the panel interest amount is more than the original PF dues. And most of those employees, half of the time I have seen, I'm giving practical experience. Half of the time those employees are not working, they are host employees. So it has become actually a racket. That many unions, many people try to create a list of employees and then they claim PF along with these people and all that. So I'm not going there, but coming back to the major point, I think Udara has given me topic as what is the impact of financial creditors and lenders, right? But what I'm saying is the economic laws have to be economic laws. That has to be understood by any Supreme Court or NCLAT or anyone. Now, what will be the impact on financial creditors? So one can be very good impact that everybody will take fast decisions. But if I am worried that this account will go for liquidation, then naturally we will also try to take fast decision, especially including my entire earlier background of public sector bank. So being in public sector bank, we end up taking our own time in casting notes and deciding on matters. So now at least there could be some change which government has been trying, which IBC has been trying, that there should be some responsibility of COC also. There should be some oversight, there should be code of conduct for committee of creditors, which we have never accepted. I mean, as IPA, we have just tried to do some polishing, create one. Sorry, I'm just making a simple statement. We did something, but we never wanted that.
Actively involved in that.
And there are compulsions, I know that, but there are compulsions, like as a public sector banker also. If you expect me, the guy who is coming to attend COC, he should be able to decide in that day itself. It doesn't happen.
RP has to do it.
Yeah?
RP has to do it.
RP has to do. So that is what Mr. Sahu in one of the forum was saying very clearly, that you expect the market participants to take a decision that day, to bid for it. Everyone should take a decision, courts will not take a decision. It's an unfair game. It's not equal. It's not a level playing field. So in that sense, you expect the entire market participant, including the bidder who is putting, let's say, 19,000 crore rupees to take a decision. But then I can take 5 years in deciding and telling that you go for liquidation. Anyway, that's a different issue. But so how does it impact the financial creditor? Positive way, faster decision, maybe decide about the liquidation in the first stage itself. But we have taken that decision many times, but NCLT never approved it. We are still in that socialistic country to some extent. Otherwise, we know very well that in many accounts, the plan will not work. And we should go for liquidation straight away. In one of the session, I was telling the same thing that let's look at the evaluation of this whole act, IBC. Remember, and most of you will remember, Section 29A was not the originally in the act. How it came? Partly because of some lobbying, but otherwise leaving that apart. It came because we realized, as at government level also, and people started giving plans, especially the old promoters, which was showing much more realization for the lenders, even on NPV basis. Now, then how do we decide? So should we give back the company to the same people? I mean, I can use some name. You're recording it. Some, let's say in Bhushan Steel, Mr. Neeraj gives a plan, or in Asar Steel, Shant gives a plan, let's say. So the value of those plans will be much higher than any other guy who will give a plan on NPV basis. So then it became a political issue also, hot potato for the government, that we give back these companies to the same promoters and then still at a lower value than the debt. And then government anyway has to give money to the banks as equity, because that point of time, banks were in a bad position after AQR. So then that is why that was the time when government felt that we should debar these people. That is how the Section 29A came into picture. That politically it was not expedient that I give back to the companies the same program, the haircut, and then the difference I, as a government of India, infuse money in the bank.
Wasn't it against the intent of the law, your lawmaker at that time?
Yes, so lawmakers have not thought of that. That's why Section 29A came much later.
In the end of the 2017, it came.
SRP, after SR plan.
So there was another thing which happened after because of all these things. So to implement this and also to ensure that these old big promoters don't get this, before 29A, we at IBA level made the evaluation criteria so difficult that the old guy will not get who is giving a plan where the repayment will happen in 10 years or 8 years. So we gave higher weightage to upfront payment. And that is what we did. And at IBA level and SBI Cap did this entire exercise after SP and all that. So that we gave higher weightage to the upfront payment. So that is why slowly your entire system, instead of resolution, actually it became recovery. So that was not the original mandate, original idea of the IBC. But slowly it became because of our own compulsions and of the country as of the system and of all the other people, advisor in the system, whatever. So today, if you really see, what is the system? Is it a really resolution system? Not really. But you can call it resolution indirectly, especially at least what JS does. In real estate, it works as a resolution, I would say. But otherwise, in most of the manufacturing, it's more of a sales system, more of a who gives me more money. And we do this entire unnecessary exercise of some 1 year, 2 years plan and all that. I mean, a lot of, it's very good thing for all we as a chartered accountants or as advocates or whatever. But otherwise, if you really see the system, what is it? So in Sweden, we were just discussing one day, there is a system that every case which, I mean, any problem is there, it is just put on sale in the first instance itself. What Chapter 11 also does actually, data. So what we are doing here, by doing all this exercise, finally we have sold it to JSW, the highest bidder. That's all. So
End result is that only.
end result is that only. So we could have decided in the first day itself. In all the cases, we should take that decision that okay, we'll just put it on sale. And if there is no buyer, put it on liquidation. If it's liquidation, so at least some buyer will come for part of the assets, if nothing else, right? And that is what finally we are doing. I mean, we are just spending some 2-3 years or 4 years after fighting each other in NCLT and cleared Supreme Court. But in the end, they're achieving in most of the cases, except maybe NBFCs and real estate, two sectors where perhaps it may not happen. But in manufacturing, certainly it is happening like. And many cases which deserve liquidation, we are going for liquidation, but after spending 4 years. So what will be the impact overall on financial creditors? I would say positively, decision making should be fast. Negatively, perhaps they will not refer many cases to IBC till we get a clarity on this point. Already the number of cases is much less because not because of anything else, because there are not many assets left in the economic system which are NPA or which have to be resolved. Whatever is left, either it goes finally to liquidation or it goes to NARCL. So because NARCL is just a warehousing for me as a bank. One good thing about NARCL that it applies to the entire ARC industry. One good thing is what is the ARC industry actually which does what bank can't do. Otherwise, why banks will sell to ARC? Now the provisioning benefit is almost gone for them. Earlier, the first stage used to happen because of the provisioning benefit, but now that is not there. So, but there are still 3 benefits which ARC industry provides over banking system. 1, aggregation of the debt. 2, restructuring on an NPA account. And 3, fresh funding in an NPA, which some of them can manage and some can. These are the 3 regions still ARC industry has an edge over the banking system in resolving the NPAs. Now, some of them may do it, some of them may not do it, but they can do it. These are the 3 points. And NARCL, at least the first point, aggregation of debt at least is there with NARCL. And the second point of restructuring also may happen if they acquire cases which are not in IBC. Unfortunately, IBC cases were not supposed to go to NARCL, but now every case which NARCL has acquired are all IBC accounts. Because till the time they took a decision, every account has gone to IBC, which was not the idea when we in fact promoted the bad bank, whatever. So one good thing is that we take faster decision, we take a decision about liquidation faster, and we don't delay the whole process. But the negative point could be that we refer less number of cases to IBC. Maybe I hope, I'm not very actually pessimistic here. This judgment, my view is it should be reviewed and things will come to normal level. I hope so. But already we have seen because of rainbow judgment, because of the statutory authorities delaying the whole process, we have started filing less number of cases because SURFACI was amendment. When SURFACI was amended, after that we have almost got the same benefits which IBC provides under SURFACI also. So if I can use SURFACI, I will prefer to use that rather than going through this whole process of IBC unnecessary and don't get anything many times. One impact which I am feeling is on the financial creditors, especially the investors, not the typical financial creditor, which is a bank, but in our system, many accounts, like say even in Bhushan Power and Steel, there were some which acquired the debt, and they had investors which were foreign investors, basically the funds, which could be FII, which could be AII. Now, we had given this undertaking that we refund the money if there is any judgment against the plan, and that undertaking is still in force. So technically, we are supposed to refund this money to the asset now, as per the judgment, as per the rule, as per the undertaking given by us. And in ARC, our own ARC, I have taken the similar undertaking from the bank from whom I acquired the debt. Now, so this process, if JSW asks for the refund of the money, let's say, so every bank, every ARC has to give back the money. So bank ke liye to theek hai, it is easy for them, they can refund. But let's come into ARC, how we will refund. So ARC will ask the same banks from whom we have taken undertaking. So those banks have to first pay to the ARC and then ARC will pay. But what about those funds? Some of those funds would have completed their lifetime, and they would have closed also. So how do we get back that money? That's a big challenge. And especially in Acre Trust, there were a lot of SSG. So, and how do we really get back that money? That remains a challenge as of today. So keeping that in view, to impact my fund business and our financial investors, those who invest in distressed assets, that if it is not certain, if tomorrow the decision can be challenged after 5 years also, 3, 4 years, then where is the certainty? And why will I invest in such asset or such asset? So even today, let us say in our, we as Edelweiss Group, we have a lot of AIFs, a lot of funds. So we used to do a lot of deals through ARC, through investment in SR. We already reduced that. And in fact, we prefer to invest more directly NCDs rather than through SR. Because there at least this type of risk will not there. But then this decision, this judgment impacts the overall IBC. So even as a distressed asset investor through NCD route also, I'll be worried tomorrow because as a fund, I don't have SARFAESI powers. Because AIF doesn't, in AIF, I don't have SARFAESI power. I have only IBC power. So if my IBC power is also getting impacted because of such judgments, because of Vidarbha, because of Rainbow, because of, let's say, this and because of this new NSE, I think all these 4 judgments have taken the entire IBC backwards by so many years, I would say. So which should worry as professionals and certainly as IBs. Number of accounts, anyway, today perhaps the accounts anyway in the system are much less, so it doesn't matter much. But till the time the next NPA wave comes, hopefully things should be sorted out. And especially the even Rainbow judgment was a very peculiar judgment. Despite government in parliament deciding that statutory dues will be lower priority than the state secured creditors, some judgments have unnecessarily created a, it has created a mud overall, muddled the whole process unnecessarily. So I think that these are the two effects on financial creditors and financial investors. That's my view. Overall, the economic law should not be, I think, treated like a civil law. We need certainty, we need finality of the any deal which has happened in economics, any transaction. I'll stop at that.
Thank you.
If you to ask any question now also later also.
I think we can take questions at the end. I request all to note down the questions because I don't want you to forget the questions at all. So please note them down. So we have never seen the financial sector, bankers, the lenders so vulnerable in IBC at any point of time in last 7 years. I will use word vulnerable. That is the only word that comes to my mind. That anybody points a finger, they are not able to even answer. So very, very, very critical situation. So with that in mind, we have a very bright legal mind with us, Mr. Ajay Shah, and he has independently, as his personal view, has observations and things to convey to us. So I request Ajay to kindly take it.
So I have a quick presentation that's more factual, but I will just start where Mr. Bansal left. That basically law is nothing but a tool. At the end of the day, there is a problem. And that problem is what needs to be solved. And that is why you have a legal framework, regulatory framework to enable that solving of the problem. The problem over here is default and a default situation. The problem can be solved either through a rectification, restructuring, recovery, or enforcement of security. It is entirely the prerogative of the person aggrieved, which is the lender, to decide the modus operandi of how to deal with the situation. For that, you have legislative framework and regulatory framework, because as far as rectification is concerned, you purely do it on the basis of a contract. You don't even need a lawyer's intervention. Technically, it's a commercial decision. You rectify the account, you amend the agreement, life goes on. But there is no haircut, so it's purely just in terms of management of cash flow. As far as restructuring is concerned, there is a formal mechanism and there is an informal mechanism. The formal mechanism has been ushered in more particularly through the IBC, but actually even before that, there was always provision under section 230, 232 of the Companies Act today and earlier 391/94, where a creditors could agree to reorganize the company or to reorganize the creditors exposure. As far as the RBI framework is concerned, the June 7 circular of 2019 still continues to allow the bankers to rejig the account, restructure the account, resolve the account in the manner in which they deem fit. So that's a framework which is already there. Then you had IBC, and of course, IBC was the new animal of the block with every positive steps to revive the debt market, bring about positivity, and most importantly, in any economics, certainty and predictability are the two important pillars on which businesses run. There cannot be a question about certainty and predictability because there is a legal principle itself, which is legitimate expectation, where there is a legitimate expectation from the stakeholder that he should not be prejudiced because of a change in interpretation of the law itself. Why I'm putting all of this, because I'm just prefacing it before we just move on to this specific judgment. And of course, you have SARFAESI, you have DRT. Now, SARFAESI, as Mr. Bansal rightly pointed out, technically with the amendment to 26E, and if more particularly, the DRT Act also 31A, and also the very fact, if you look at Section 9 of the SARFAESI Act, it's very wide. So therefore, there were already enablers there, but because everybody wanted a court process so that the stakeholders, what was the reason? It's not bankers cannot take a decision. Ultimately, it is the bankers taking a decision, but it gets validated through a court process. That was the intent. The only legal validation is what was required by the court, even for IBC. So correct me if I'm wrong, because that was the clear intent of the legislative framework. But what it has become more a subjective tool. It is saddled with conditionalities. It was supposed to allow flexibility. It was supposed to allow agility. It was supposed to usher in a quicker redressal. As against that, today we have made the legal framework, as Mr. Bansal highlighted, basis the various judgments. The courts have gone into a jurisdiction which is very dangerous. It is basically, in legal terminology, we say judicial activism or judicial adventurism. It's a very thin line. It almost cuts corner there simply because what it has done, while legally some of the principles may be right, and that is a point of concern. And that point of concern arises because we have made the law very subjective. Otherwise, if you come to think about it, apart from few sectors which he highlighted, whether it's real estate or NBFC, every other sector is a sale. A sale happens even in the government level. What do? You do a pre-qualification, you qualify bidders, and then you have a H1. Highest bidder who gets the mandate in a government contract is the L1. The lowest bidder gets the mandate. What have we done? We have decided to have a scorecard. We have decided to introduce. See what happens when you over-regulate. What happens? The law is clear, but you have also a regulator. The regulator also has a role to discharge. And after the regulator, you have agencies. Now everybody has a role play. The more role play you create, these are opportunities. When you make objective things subjective, it is a discretionary paradise. And the moment there is a discretionary paradise, it is open for all. And that's exactly what has happened in this particular judgment. Because the way in some of the processes, you have also given the court a handle. Now, right or wrong, ultimately, the law, also the punishment has to be commensurate to the action. In this particular case, the investors have invested, there's a contract which has been concluded. In law, you have two kinds of contract, because ultimately this is nothing but a contract entered into by the COC with the successful resolution applicant. A contract can be avoided under law only in two situations. Either it is an avoidable contract or it's a void contract. A void contract is something which lacks legal substance from the onset, which means it does not qualify as a valid contract under Section 10 itself, which basically goes to the fact that if there was a problem, the problem should have been addressed at the level of NCLT itself, that the 31 application should not have been allowed. But having allowed the Section 31 application on the premises that the commercial wisdom of the COC prevails in context of the deal making, so long as the contours of the legal and the regulatory framework has been met, there should not have been any judicial intervention. Now, once NCLT approves, the NCLAT should have basically, just allowed the implementation and everything would have been done ahead. After that, the Supreme Court also never granted a stay, but some of the conduct also in this particular instance gave headway to people. So this is exactly what I'm going to just be discussing in the judgment. While the judgment per se unsettles everything, it is not a step in the right direction because it kind of undermines certainty and predictability. I was speaking with my managing partner and we were generally discussing that as lawyers, it has become a real difficulty to advise which way the court will go, because it's almost like taking a punt one morning and you do not know what the court judgment is going to be. And this is something which is increasingly happening at NCLAT, at NCLT, in spite of a debt and a default clearly existing. NCLAT goes on to say, please reconsider whether there is a asset liability mismatch or not. But where is there under the law? The law has moved away. SICA was more on the net worth. As far as IBC is concerned, it's default. But so we are allowing some of this conduct to happen. What this particular judgment on the positive side may do, I will start with some positive. We have criticized it so much that NCLAT, it has pulled up heavily. It has really questioned NCLAT's jurisdiction and getting into things for which it was not even intended. It has, to a certain extent, questioned the conduct of the RP as well as the Committee of Creditors. Now, as far as the Committee of Creditors are concerned, one has to realize there cannot be any conditionalities imposed, because ultimately it's a commercial decision they are going by. They need to recover the money, they need to resolve the account, but ultimately it is to yield resolution and recovery for them. Having said that, I think some of the way the procedure it was run gave legroom to the Supreme Court. Like one of the particular thing is when the appeal was filed, GSW did not go and kind of implement the plan despite there being no stay, despite NCLAT clearly saying that you will not be saddled with the risk of ED. Though NCLAT did not have the jurisdiction, they still clarified that ED will not come into the picture. And then 32A was brought in. 32 was brought in because of the JSW issue. In spite of there not being a stay, nobody wanted to implement. The creditors initially took a position that let them implement the plan, and they gave an undertaking on 6th of March 2020 to say that in case if the appeals are decided otherwise, we will return the money. Now that became like a sore point in the entire story also going forward. Later on, they were at combative stage because GSW said unless there is certainty with respect to the ED issue, I am not implementing the plan. Later on, after a few discussion deliberation over a period of 1 year, they decided, okay, I will implement the plan, but implement the plan on the condition of the lender's undertaking, etc. Now, all of this technically just adds to the problem. Sometimes we are also responsible for, giving rise to the problem. So therefore, as I always believe, though it's not a lawyer's, a lawyer will never advise to simplify things, and I think so will the chartered accountants. But as a professional and purely in the view of finding a solution, the simpler you keep things, the better it is for all. Transparency and bona fide will never be questioned when there is simplicity. Transparency and bona fide will always be questioned if there is subjective element, if there is discretion being exercised, if there is things which are being done in smaller groups. Now, just in context of the judgment, I think the facts are known to everybody. 2017, it was part of the Dirty Dozen account. And, basically the process started on July. What happened? Oh, sorry. So basically by 2019, the matter went to the NCLT, and in September 2019, the NCLT approved the plan. This is like 6 years back, 2019 September. Thereafter, appeal was filed by the operational creditors and the promoters to NCLAT. But even JSW filed an appeal. And that appeal has become one of the troublesome areas as far as the Supreme Court observation is concerned, that you were a successful resolution applicant. How were you aggrieved by the plan? It is your plan which is getting implemented. The appellate provision under 61 is very clear in context of the contours of the appeal itself. Where do you fit in? How did you come into the picture, and why did you even make an appeal? So they said, no, we appealed with respect to the ED issue. We appealed with respect to getting certain modifications to the resolution plan or clarifications. These were the two fundamental things. And CLAT later on ruled both in the positive, that the ED technically is subservient, which it could not have done as observed by the Supreme Court, and rightly so legally. The second thing is that they said that they were wanting to comply with the amendments to the CRP regulation. Therefore, those modifications were required, and NCLAT has allowed those modifications. Now that, honestly, it was between the COC and the resolution applicant. Meaning the very fact that you desire too much of clarity sometimes leads to ambiguous situations, as is here. So NCLAT, those two fundamental things became a sore point. And that basically became one of the fundamental grounds given by the Supreme Court. This later on, everybody went into appeal into the Supreme Court. JSW did not go into appeal because JSW has now won the matter in NCLAT. Now it cannot go into appeal. So what it did, it filed an I in the appeal filed by the COC, filed by the various other stakeholders. It filed an I seeking a clarification that unless the EDU issue is resolved, I will not implement the plan. There is no stay. We all as lawyers are taught, and chartered accountants, you all are practicing IP, that if there is no stay, you can do what you want, because technically there is nothing called sub judice, meaning everybody understands that. But nobody implemented the plan. It gave further, leg room for the others. After a period of 1 year, you decide to implement the plan. And initially, the conduct of COC and JSW at Supreme Court was at loggerheads. And then suddenly you come together and you start behaving as though you are one and the same. Now, this raises doubt. At the end of the day, you have exposed yourself to the judicial scrutiny. Even if you were to do such things, you should have kept the fight to the boardroom, not to the courtroom. Meaning these are very few things, more on a practical level, because the law, as they say, just sees black and white and it leads to grayness, which has happened in this particular instant matter. Now, as far as the, I went opposite direction. Facts we discussed. So breaches under IBC, I was speaking to Mr. Udairaj, he said Form H was technically filed and the court has made a wrong observation. So if that is the case, then clearly this is a ground for review. Because, and so in this particular matter, there is only one legal remedy available. You review the matter under Article 137 of the Constitution. But review is a very limited jurisdiction. And review normally goes to the same bench which decided the matter. Like what happened in Indira Banerjee's matter of both Rainbow and Vidarbha, she only reviewed the matter and of course she struck it down. But in this instant case, I think Bela Trivedi has retired. She has gone out. So Justice Bela Trivedi is out. So the review will come up before some other judges. Hope that under the ground of review, they turn the clock back and they kind of put, of course, there should be strictures passed for if they observe that there's been judicial violation. But those strictures should not be undoing the contract, because undoing the contract, there are a lot of indirect constituents who gets impacted. Like as Mr. Bansal said, the investor in the SR of the ARC, why should he be prejudiced? He saw India signing and he invested into the SR. What wrong has he done? Some stakeholder who has invested into JSW private equity, or people who have invested into JSW, what wrong have they done? Why should they be prejudiced? Because this way you will lead to a similar situation what happened in the 2G scam, what happened in the coal block allocation. one way we speak about, the certainty and predictability, and then we let everything goes to the, wind. We cannot allow that. If assuming they are wrongdoing, strictures should be passed and strictures consummate to the wrongdoing. In fact, I was just discussing outside the room. There is one particular judgment of on the Sakal paper matter, where corporate actions were taken in order to elbow the erstwhile promoters out of the company over a period of time. Those corporate actions were questionable. The court, in its language, clearly said there is too much of water which has flown under the bridge. You cannot undo everything. So therefore, they levied a penalty. So therefore, the fundamental principle, one of the things which we are taught in jurisprudence in law is a tool to achieve a purpose. It is not supposed to lead to what is called absurdity. And anything which leads to absurdity itself is capable of being challenged as a bad law. The very fact we allow some of these things to happen is a problem. In fact, I was speaking to Dr. Vishwanathan, who was the chairman of the bankruptcy committee report. And I said, sir, before the Vidarbha, if anything, Supreme Court said you always made corrections. You allowed legislative changes. He said, it's not our duty to keep changing the law because the court gets into adventurism. Because what has happened? You allowed Vidarbha to get away. You allowed Rainbow to get away. Now you have this, and then you have the MPID matter, which has come before. So somewhere there has to be a clear, maybe a parliamentary intervention or a legislative intervention, because at the end of the day, the law is supposed to be purposive. A law cannot be not achieving a purpose. The very fact that Supreme Court exercised its inherent power under 142 to declare liquidation, it just shows, how can you exercise inherent power to kill the objective of an enactment? It is so surprising that Supreme Court in the Byju's matter, when NCLAT exercised its power under Rule 11, said, why do you exercise inherent powers when there are specific provisions? So one man's meat is the other man's poison. I mean, it doesn't work that way. So law has, the beauty about law is you have some of these very residuary powers. 142 of the Constitution, Rule 11 in your NCLT rules, Section 151 of the Civil Procedure Code. These are inherent powers. Inherent, used sparingly, and not to defeat an explicit provision. So technically, if you ask purely on this 142 itself, is a good legal ground to say that the court cannot exercise inherent power to order liquidation. The decision of solution and the decision of destruction is for the benefit for which the law was created. The beneficiary of the law is who? The creditors. They can decide to salvage or destroy the vehicle. Court cannot take on that mantle of deciding for the creditors. In fact, this particular provision, 142 and the liquidation, should be a good ground for saying that prima facie there is an apparent error in the interpretation of law. So this is, of course, I'm sure that all these advices will be given and taken up. If 137 fails, then there is what is called curative petition. And the beauty of the curative petition is it originates from inherent power of the court itself. And in fact, the paradigm of the inherent of the curative petition is very limited and very sparingly used. Curative petitions are normally used when a guy is going to be hanged or something is going to happen. In a situation like this, I'm not very sure, just purely from a legal standpoint, that if the review fails, I'm not sure that, while everybody wants to add, or we will fight till the cows come home, but reality remains, they are jurisprudence, they are settled, and they will not unsettle the entire jurisprudence for addressing one matter. So possibly two things which I see, either a legislative framework, some changes, the judicial review being allowed. If these two things don't happen, then we have to live with the law. If we have to live with the law, then it's important for us to understand some of the findings and going forward, what we need to be wary about. So some of the observations made by Supreme Court, Form H was not there. They said that the time frame was not adhered to, but it's very debatable. Because even in the SR judgment, they've said that the time frame requires to be adhered to, but we all understand that running an IBC process is not simple because of the multitude of stakeholders involved. So therefore, there has to be shift to allow things to happen if time is required. And in fact, the Limitation Act, which is the basic fundamental law on limitation, which basically deals with time frame, there is provisions of exclusions. And provision of exclusions are litigation, provisions of exclusions are if there is something unforeseen, etc. happens. So therefore, even in the instant case, honestly, the ED attachment happened after the matter went to NCLT. So it is unforeseen. So therefore, to say and just brush all of these events aside and say that Section 12 has been breached, to my mind, is saddled with some kind of legal flaw and can be possibly one of the grounds of the revision application. Section 29A. Now, Section 29A, assuming that there is a problem, the court could have clearly asked the RP and the COC, please get us affidavit on record. Why punish them for that? Assuming for a moment, even if they had a doubt, they should have clarified. Now, SR, what had happened is 29A got breached because the Ruyas had set up the bank account with VTB. And that became a real contention. And they said that technically that it is a flaw. But over here, there was nothing. No observation of this effect has been made. So even if they were not happy with what was filed for 29A, they could have always asked that please just update and keep it on record. So that clearly should not have been done. Now they are saying that, the RP did not act properly with respect to the PUFE transaction. Now look at the irony of the situation. PUFE, the animal which we all talk about in every IBC process, and how much has been the recovery? Sir, if you can throw some data, I am not very sure how much recovery has really happened on the PUFE. Because whilst applications are being filed purely from ticking the box, not much has really happened. The intent is right. But again, if the intent is right, but if the law cannot be implemented, meaning one has to really relook. And these are the kind of things which create a problem. Now, operational creditors were not prioritized. Now, for not prioritizing the operational creditor, assuming that the argument they said is that the operational creditors got their money after 900 days, and it's not right, they should have gotten priority of financial creditor. Give them some extra money. Operational creditor will not ask beyond money what has been agreed to under the plan. And if their grievance is priority, you compensate priority through economics. Where is the need to unturn the plan?
So they will also have to return the money.
Everybody, stakeholders, everybody.
In fact, they are penalized.
So what the Supreme
How they will pay?
Exactly, and I think with the funds which have extinguished, how will they pay the money? And what the bankers, this money would have gone to the P&L because it is a clear profit. It is a right, all these are write down loans. Now, if there's a profit, money would have gone to income tax also. Are you going to tell the income tax guys, now please return the money? It's a auditor's paradise, it's a chartered accountant's paradise, I would say. And what do you do? Because this is uncertainty then. Now, further the CIRP, so this time period we discussed. Now, commercial wisdom of COC and failure of COC to perform its statutory duties under IBC. Honestly, there is only one statutory duty of the COC, the fiduciary duty to make sure it takes care of all stakeholders. So long as they do not take an action which is prejudicial to any one stakeholder, there should not be any other grounds of judging a COC conduct. Because the moment you get into that, then that will become another piece of legislation on which everybody will start then, kind of finding loopholes and acting on it. Now, in this particular thing, I think the conduct of the COC was said to be, differently varying at different point of times, and therefore it was remarked as an element of collusion with the successful resolution applicant. Now, honestly, assuming that were the case, they should have punished the COC with some penalty, but why undo everything and punish everybody? And that also the COC was acting through a smaller group. You should have gone into that. If the law wants, if they want to find mistakes, why punish everybody in the larger situation? Because you had a monitoring committee, you had a monitoring agency. So you should look into these elements factually without getting into that. To undo the plan, to my mind, again, is a problematic area. The Supreme Court has remarked, saying that the commercial wisdom is not a matter of rhetoric, but also well considered and law-abiding decision. Honestly, any conduct of the COC should be only tested on the strict grounds of Article 14 of the Constitution, arbitrariness. or discrimination between two stakeholders in the same position and nothing else. Like just like how you test a government organization with respect to a tender process. Because by getting them into the rigmarole of processes, etc., you are undermining the very purpose for which the law has been created. So they have said that the COC, by allowing time, the COC in a manner acted in conduit, all of this is not right. And one of the remark which Supreme Court said, because the lawyers kept emphasizing that it is fait accompli, that if the matter has already been completed, the court should not undo it. I think this is where the court also would have got rubbed onto the wrong side, saying, are you trying to tell me just because you implemented the plan and you gave me an undertaking that I will return the money, you mean all this is just a showpiece which is going on? Now, see, these are all conduct. One has to understand even the judge is a human being. And the conduct of the parties also kind of, influence the decision. So this strong remark itself, one has to really understand that, how you would want your lawyers also to conduct the processes in NCLT and NCLAT. Sometime by making a statement, are you opening up a Pandora's box? One has to just really deliberate and consider that, because just an undertaking or just getting influenced, are you wanting to tide over a smaller problem to get into a larger issue? One of the point which Mr. Bansal said, there was no stay. A stay is granted for three counts. There has to be a prima facie case for stay. There has to be a balance of convenience for stay, and there has to be an irreconcilable harm which is to be caused for a stay to be granted. If these three things did not exist for a stay to be granted, now for such a judgment to come itself, it's really a concerning issue. But I think a lot also has to be said in the manner in which the proceedings were conducted. And one has to really relook that whether sometime really being aggressive, really going hammer and tong on certain things which you think are to your advantage, are you opening up to various other issues which could be best avoided? Gross contravention of the provisions of IBC by JSW. So these are verbatim picked up by the promoters, petitions or appeals which have been filed by the operational creditor, where they have said that 32 has been breached. They have also gone on to say that technically the issue on EBITDA, the EBITDA issue was not decided by the Supreme Court, but they said that if the resolution applicant does not implement the plan, should they be entitled to the benefit from the date on which the resolution plan is deemed to be approved, or whether the EBITDA should accrue to the benefit of the creditors. While this issue has not been decided, the Supreme Court has said because they have turned the plan aside, but this is an important facet which I think every COC should clearly articulate or allocate it as part of the resolution plan or the process, because why leave something for the courts to come and intervene? So again, as I said, willful delay by JSW, motive behind implementation, malified conduct, and role of resolution professional and COC was kind of questioned. The court did not come down heavily on NCLT. The court said that it should have examined the plan, and if 32 non-compliance was there, they should not have approved the plan under 31. But the court has very heavily come down on the NCLAT, because in the manner in which they entertained the JSW's appeal, the manner in which they dealt with the ED issue, the manner in which they allowed the modification to resolution plan. So these are some of the very strong observations made by Supreme Court. But it is interesting that, this NCLAT and NCLT, both of these technically come under the Ministry of Company Affairs. So it is purely under the diktat of the executive. I think, sir, there has to be some amount of, level of discussion while it is happening. The MCA should really intervene and get some of this in house in order, because the way some of the judgments are being passed in NCLT and NCLAT is also of a concerning. Recently, a CCD, despite a settled principle, they have said CCD, the coupon, even if it has been agreed to be waived, the court has ignored, saying, I don't agree with the contract, but because principally there was a requirement to pay coupon, it is a default. What I'm trying to say is, why does Supreme Court come into the picture? Supreme Court is your true blood legal system, and CLAT and NCLT are quasi-judicial bodies. They are supposed to be acting within the realms of what the law has prescribed. But because of this Rule 11, and because the way NCLAT and NCLT have been behaving, or at certain times, not so well behaving, it has resulted to some of this situation. So therefore, I think this particular judgment, if one positive, it has really come down heavily on the NCLT and NCLAT, and a lot of introspection is required here. And the delay, as Mr. Bansal said, is possibly one of the things which should be addressed. It's an economic legislation. It is time value for money. A resolution plan with the same amount being implemented after 2 years. I'm not a chartered accountant or economist, but any guy will tell you that is it the same value? There should be, some penalty to that. There should be economic demands that, the COC also, when it is now prescribing implementation of plan, should factor some of these, because otherwise you are incentivizing delay. A lot of times people have become successful resolution applicant and are scouting for money to be able to fund the resolution plan. But this is dangerous. We are getting into a dangerous territory and terrain. And if Supreme Court has really, kind of hit the people on the knuckle, there is some merit to it. It is not entirely without a requirement. You cannot use a successful resolution plan as a bankable document to go and get a sanction letter. That cannot be the intent. Pocket mein paisa nahi hai, don't bid. You don't have the ability to resource allocate at the time when this is happening, don't bid. Otherwise, you are setting a wrong precedent. What is happening? I know of so many matters in NCLT where I will name XYZ who are commonly seen, who are almost like just collecting mandates without money in their pocket and then going out and short selling. This is not the legislative intent. And this is not, something everybody complained about SICA and BIFR. That was much before even I started my practice, because I started in 2002 and BIFR is 1985. But everybody complains, and I, know Mr. Lodha, Mahendra Lodha, who was one of the stalwarts, and Alok Dheer on BIFR. So they kept, discussing about the club culture in BIFR. But are we kind of, promoting this in the NCLT and NCLAT? Because then that is dangerous. Then that requires executive intervention. That requires some amount of IBBI intervention and the knuckle by the Supreme Court. So therefore, while we may keep criticizing, but one has to also introspect. So if you ask me, the positive side of this judgment is some introspection in the manner in which we conduct the IBC process, to try and do away with elements of subjectivity, to try and do away with elements which can give rise to, subjective arguments. Be objective, be transparent, and always please judge your actions on bona fide. If any action which you believe cannot tomorrow stand the court with the bona fide element, please rethink. The specifics of the judgment, these are the 5 points which the Supreme Court has said specifically. RP's failure in discharging duty under CIRP. The COC has failed to exercise commercial wisdom. Conduct of the SRA and the resolution plan not being in conformity with 30 subsection 2 and the behavior of the NCLAT. They have actually paraphrased these 5 points as a preface to the order. And what does the order say? I have just called out specifics of the order. Because as lawyers, we need to be specific. The judgment and orders of NCLT and NCLAT is set aside, which means there is no resolution plan in place. The resolution plan being in non-conformity with law is rejected. In view of 33 and exercising the power of under 142, the Supreme Court has ordered liquidation. I think this should become the ground for a review petition. The payments made by JSW to financial creditors and operational creditors, as also the equity contribution, if any infused, under the garb of implementation, should be basically, returned back. Basis the statement of senior advocate Dr. Abhishek Manu Singhvi appearing for the COC, recorded in the minutes of 6th March 2020. And what he recorded is very interesting. He clearly said that he will return the money. So therefore there is, it gave leg room. The impugned judgment passed by NCLAT allowing so-and-so is set aside, so that is not relevant. So I think that 142 possibly should be used effectively to review. And as far as returning the money, there is a concept in law called hardship of law. The law cannot result into hardship. So possibly this should be one of the grounds to argue in the review petition that you cannot have a situation which results into hardship to a larger set of people. In law, there's a principle called conflict of interest. Assuming that one person's interest is aggrieved, but if we have to undermine that interest, be it so to protect the larger interest. I think in this particular instant case, the larger interest will be undermined then. So
Much
it's
wider.
much wider. So therefore, I hope, Supreme Court takes it up strongly, and let's wait for the result. And way forward, we discussed resetting the clock after 4 years. How do you refund the money? How do you undo all the mergers which has been approved by the court process? How do you return equity other than for capital reduction or a buyback? Now, these are all going to be nightmare for all of us because everybody will want a legal and accounting advice. Meaning, I do not know if we all have answers for it. Supreme Court sets boundaries of COC commercial wisdom. Review application followed by curative is the way out. Invocation of Article 142 of liquidation, I think this should become a problem and this should be a ground for review. And jurisdiction over NCLT and NCLAT, hopefully better sense will prevail going forward. Thank you.
Thank you. Thank you, Ajay. That was really a very detailed analysis of the whole case and what exactly went wrong and what is the way forward. So before we take questions, I will just put out a view that came up as to what care should we take as resolution professionals.
Introspection, really.
So I would always say I was doing good till now, so I will only look forward. So I will not introspect. But that is not correct. We have to look at our own cases also, which happened. वो बोलते हैं ना वो जो पकड़ा नहीं गया वो चोर नहीं है. That has happened till now. So we all might have made mistakes in the past. Mistakes because of what we are discussing now. But out of these 5 areas which Supreme Court has pointed out, 4 are the issues which relate to resolution professionals that we will discuss. But what comes to my mind is even the other stakeholders, the COC, the SRA, the courts, everybody has given some decisions in their own way. As an RP, we might be required to even look at what they are doing and caution them about what the law is, because it has been held by many NCLTs and NCLTs in the past that RP is also torchbearer. He has to tell others, educate them of the law and tell what is right and what is wrong. So that is an unwritten responsibility that will lie on our heads. Other than that, we will look at 4 issues: 29A, Section 12, Section 30, Subsection 2, and avoidance applications. These are the 4 specific points which have been pointed out. So far as Section 29A is concerned, certainly there is a record of Form H having been filed on which there are comments in the judgment. However, they said that Form H is not really a compliance certificate as it should have been. They say that you have just mentioned and referred to the affidavit given and said that it is deemed to be compliant. Even that word is not used. So they say it's a collation of document and not really a compliance certificate. So the language of Form H, when we are writing Form H, has to be improved. So we have to do that. Rather than referring to others documents, we will have to come to a conclusion whether that particular SRA is 29A compliant or not. How we do it, whether we depend only on the affidavit or we do independent analysis from experts. So we have been doing that. In my own practice, I do that. I advise that you all do that. After Bhushan judgment, COC also will fund you for that, because funding that particular process used to be a problem. We have even seen that COC says whoever is the winner, only that we will do 29A. But I think after Bhushan, everybody will take a cautious approach and they will say that, okay, do it. There is one way to do it. In RFRP, you can put a condition that you provide a certificate that you are compliant from an outside agency. So that can be a condition. I don't know how much legal it would be, but that comes to my mind that instead of we spending the money, along with the affidavit, we can ask them to submit an analysis so that the cost is shifted on them and time itself. Because when it comes with the plan, it is predating the plan and the time is saved. If we do it after plans are received, उसी में 2-3 हफ्ते चले जाते हैं. So that is one thing. Section 12, yes, we have to apply for extension and exclusion in time. I don't really have details as to why it was missed in this case, but I am very sure that you all do apply for extension. But in last 15 days, I had 2 extension applications before NCLT Mumbai, and they were not very kind with me. They asked many questions, and I was taken to task in one of the matters I was advising. COC was instructed to take a decision on the plan in the last 20 days remaining. Nothing more was allowed. They say, come to me on 20th day, and then we will see what can be done. They kept the decision pending. In one matter, we were given 1.5 months and said that whatever is there, you come back after 1.5 months. You can't come to us so early. Even if you do all the efforts, show us the efforts, and then we will take a decision in the last 7 days of the period. So that approach has already changed, and I think that will keep all of us on toe. But making an application in time is very important. That is a technical default we don't want to do. Section 30 subsection 2 is of paramount importance, read with regulations. So nothing can be said about it other than a very critical issue about the implementation and viability of the project, which we have seen that in many cases, what COC does in their own boardrooms, we are never aware, because that is not required to be noted other than by one single line, that after considering feasibility and viability, that also after a lot of efforts, we have been able to include that in the resolution. Previously, we were not able to include that in the resolution also. But I think some kind of background exercise has to be done. I can see that even a 10 lakh rupees loan has more assessment papers created than for a large resolution plan on the side of feasibility and viability, how it will go on, how the project will sustain, how the company will be going concern. I don't think much of that is studied. So what can be done is, again, in RFRP, we can ask the SRH to submit TEV reports with that. So if they submit TEV reports with that, majority work is done. COC can look at the TEV report and they can take a decision. So this can be done. I have done that in 2 projects successfully. The SRAs were not ready. One of the SRA was SW only in one of the cases. After a lot of efforts, they did it, and that helped us, because the questions were asked about feasibility and viability, and COC's counsel said that yes, TEV report was there, we analyzed, we asked questions, and we were satisfied. So that can be done. That is my suggestion. In avoidance applications, yes, they have to be filed in time, but a lot of times data is not available. So it goes back to section 19, subsection 2 applications which are not successful. You don't have data, you don't have information, so you can't do proper avoidance application. And when you do and you file that application, then the promoter will come and say, I don't know how this has been made. I don't have this data. I have nothing. Submit me the data that you have depended upon in arriving at this. And then I will study, and then I will tell as to what is done. And they are being heard, and they have been given relief also by NCLTs many a time. So that also has to be looked at by all. So these are the only 4 points I want to make from RP's point of view. Other than, of course, whatever COC is doing, we can be their friend, we can be their guide wherever we know a little bit more. And SRA also we can try to guide. We all are on the same side, so we have to work together. We cannot in any situation become adversarial to each other. That happens, the process starts collapsing, cracks start appearing. So that is the only input from my side at this. Now let us proceed.
This observation also. What was the necessity to put a fair,
as the law originally, sir, as the law originally standard, PUFE was supposed to be done in liquidation side. During CIRP, PUFE was not prescribed. It was prescribed later in 2018. 2017, PUFE was part of liquidation process.
And even though now the responsibility also given on liquidator in case it is not, you can do it. And one more thing, as you said, like we COC and all has to be on one side, we all have this thing. But as the fact says, it cannot be. One side is from our side to them.
Yeah, always.
It cannot be from their side to them. So he's there, he can say what you want to say. But this is the fact. And that's the reason it happens. All wisdom, everything is set aside. What has been done with the COC is a commercial wisdom. What has been done with us is only the following the law.
So that is from my side. If we are able to demonstrate what we are doing, then certainly IBBI will save you. because if anything goes wrong, like here observations are made against the RP, it will go to IBBI. IBBI will then repunish if they find something the RP, because he has already been heavily been I would say strictured in previous past. So there is a possibility of that happening if that is not taken away in the review. That is my
Another observation passed by the court is that a long time taken by RP to put up the IS for approving the resolution.
So that
is four months they have taken.
that appears to be case specific, sir. We all take our efforts to file applications in.
Just observations.
Yes,
On that, what do you have to say?
That is an observation, yes.
They have taken
But
4
you
months to
understand-
pass the plan which was approved,
To put up before it.
to be put up before AA.
So that was too long. So that must be done promptly. Doing promptly is one part. Our legal friend is sitting here, but whenever you want to file an application, immediately write an email to your counsel that this application is to be filed. Kindly send your quotation, start drafting. Unless you put it on record, your efforts are not seen. If you keep on talking to them and nothing happens, then the blame will be on you कि यार एक महीना आपने कुछ भी नहीं किया. भले वो एक महीने बाद 3 दिन में आप फाइल भी कर दे, but you should be writing to the law firm that you want to file an application under this particular provision. Send an email. They will send you a quote. They will never keep quiet. They will send you an email immediately of the quotation. You will have to approve that, and then you will have to proceed.
So the 29A also, see, benches asked us, where is RP certification? Oh, you can take a certification from the SRAs, the RP certification, but especially writing that and giving to the COC that we are certified. And as you know that being a chartered accountant, not as a lawyer, but we have to do it our own, even though we get it certified from any other lawyer of the SRA.
Hey, what
That ball, again comes in our court.
Is a big challenge because
And then whomsoever agency you appoint,
what
they
practice we are following right now is we approach our legal counsel, and if they are comfortable, they give us a composite certificate for our own consumption. It cannot be shared outside. That the provisions of 30 subsection 2 regulation 38 39 are met, and it is 29 compliant, etc., etc., based on, of course, evidences that have been placed before them, and we adopt that language to give our own certificate. So we do provide a certificate to the COC about the plan being compliant. So we do that in most of the cases. Yeah, that is, formage is covered, but what the observation is, sir.
You have to arrange it separately. People the benches are asking this thing, especially.
मैंने वो अरे बराबर है 29A का सबसे बड़ा चैलेंज क्या है? The hierarchy of relationship is too wide. So first of all SRAs who are there has to give you the list of that related people. If they give a limited list and then you do a search on that limited list, then your certificate has to have that clause very clearly. Which will absolve you from that liability. But if you just give a blanket certificate, then it is your liability.
Yes.
Most of us are chartered sitting here.
Yes, of course.
जैसे CA में हम certificate देते हैं, we subject to some. जैसा इधर भी subject to दे दें, आगे जाना है. और क्या करोगे?
In one of the webinars, I heard about prevailing thought process of giving importance to the spirit of 29A over the letter of 29. Particularly regarding this case, they said that maybe in the letter they were disqualified, but in the spirit they were not disqualified because they were in the JV together with VSPL. But that section 29A is to stop the promoters to come back. These are not the original promoters of VSPL, so 29 shouldn't have hit them. So I don't want to say it was done purposefully, but this discussion, though not recorded anywhere in whatever has come before us, there was a discussion about 29A in one of the COC meetings that is known to us. But why that analysis was not done and why that whole process was not concluded, I think this thought process might be one of the reasons behind that.
29A, I think it's a Pandora of issues. And if it is discussed, then it goes for peace together. And at the end, there will be no solution.
As an RP, we can't say letter or spirit, let us to spirit.
That is what I'm saying. That what this case law did, there was a law which was supported by some jurisprudence. And today we are back to the law. the jurisprudence, what has evolved over these 5-7 years, has been turned back, and we are back to the law. Now, when you talk of spirit, basically of law, and it is the law what came into with BLRC. 29A should not have come then, because law never anticipated the promoters not coming back and taking over the things. What sir told that NPV were offered higher, the idea was the economic resource which was stuck should come back to the society. That was the ultimate object of this law. Now, in which mode it comes, and option be given to the person who is caught in this vicious circle of liability to come out and live a fresh life. So if that person itself wants to get again back into that vicious circle, it is his wish. The government should provide that opportunity. That was the key points, you can say, and the object of the law. Over a period, in the initial days, I had fought in one of my cases. That time, that principle of natural justice came into. अरे यार default किया है, principle of natural justice कहाँ से लेके आया? Lawyers came down with the principle of natural justice, and now it has become a part of the system. Law does not. There is a default. Yes, it is a default, and that default is taken, accepted, and it has to go move ahead. So what has evolved? That not only this is a tribunal, NCLT tribunal came into play. Take any tribunal. First 6 years, they will perform excellently well because the law is being followed. By that time, 6-7 years, all advocates come into play and come out with some various jurisprudence supporting their clients. This jurisprudence comes into play and the tribunal start following the jurisprudence. And one fine day, some type of Supreme Court judgment which says that all this is bullshit, throw this out, come back to what was originally. So again, the key problem by this is RP, as a RP. Other things, okay. One best part of this was, this is the first case law where I saw commercial jurisprudence, commercial wisdom of COC being challenged by Sarkar. Otherwise, all cases, it's a commercial wisdom of the COC, leave it aside. We cannot interfere. First time someone said that commercial wisdom does not stick to them. They have to prove what is commercial. If they are not proving that, then that commercial wisdom cannot be said to them. The freedom cannot be given. And that's what Ajay also told, that this will be.
Just clarify that. So they've not said commercial wisdom we will undo.
Yeah.
They only said commercial wisdom. It cannot be a case where it is not subjected to the test under the law. So if there is any breach under the law, you cannot negate that under the guise of commercial wisdom. See, what has also happened is because the case Sasidhar matter and line of judgments of the Supreme Court, they said if the commercial wisdom, because ultimately this law is created for the creditors. If the creditors decide this is the best thing for us in context of a default situation, let us uphold that. That was the entire purpose. But what was also becoming is under the guise of commercial wisdom, the processes became a little bit of a concern. And this is what Supreme Court has said, that under the guise of commercial wisdom, you cannot run processes which otherwise do not comply with the law or which do not meet the requirements of the law.
Well, I will add something here, sir. Bansalji will be able to add to it. So far as I know, this particular case happened at the time of COVID. The overall situation was very bad. Nobody was offering so much of amount as JSW was offering. They had lost 2 big bids in the past. They wanted to do it, so they actually paid far more than anybody else was offering. So commercially, I think this was the best deal for the bankers at that point.
As on that.
So in the hindsight, you may say everything is wrong. But the commercial wisdom of the COC, I don't think should be put to question just like that, because today you see that it can be wrong. Bansalji, your views on it?
See, basically, let us understand, in 2019, what was happening? Overall, as a banking industry, after 2015 AQR and all, that NPA levels were very high. So that is how the IBC came into picture. Now, first 12 cases started in 2017. Now, and who was the lead here? PNB was the lead in SBI. PNB was the major banker. 2019 when this came, and as you rightly mentioned, JSW could not get Bhushan Steel and could not get SAR, and they were desperate to get another at least big steel plant, this was the third one, biggest one available. And there was another Monet which actually was taken for family reasons, and then Electro Steel. Now, we were getting, if you really ask me, we were getting very good value. JSW was also not giving initially this type of value. Tata's were much less. In fact, Tata's objected also when JSW improved the value. And third one was Liberty, which anyway, lenders were not giving any credence to that. Now, the amount which we were getting was very good from that perspective as lenders. Secondly, in 2019, if you really ask me, steel industry was not doing well. It was in a quite bad position in steel industry as an industry. So even JSW didn't have the money, you ask me, really. That is why it delayed also. And it is not the only company which has delayed. You can find 100 other bidders who kept on delaying. And as Ajay mentioned, people nowadays get the plan and then raise the money. Now, so there was a reason because they didn't have that type of money. They overbid in that sense. They paid a very high price because they wanted somehow this company. The only thing which I said somewhere else also, which we could have done and which was done, that how to share the EBITDA during this, which was a clause. So in fact, JSW offered 450 crores, and somehow PNB didn't take a decision at that point of time because of these appeals pending. So COC said that these appeals also be decided because one appeal pending from Sanjay Singhal was this only, that the beta should be shared and that this entire money should go to lenders so that my liability as guarantor comes down. That is how the whole thing started. His appeal is that only. Now, which knowing very well, somebody was asking about PUF transactions. So we can't recover from PUF transactions in any case. And the same guy, if you ask Sanjay Singhal whether he would have paid a single paisa against the guarantor, even if it goes down by 100 crore rupees, I mean, that itself is a question mark thing. So these are all just appeal filed. One thing which I find surprising from the judgment is you are talking on an appeal filed by a guy who is not 29A compliant. Actually, Sanjay Singhal can't be 29A compliant. And you are taking a decision on that appeal after 5 years, while you are raising doubts on 29A of JSW itself. And this judgment is very khichdi of so many things, I think. It's not very clear what is the purpose, as Ajay rightly mentioned. What is the purpose?
No intent.
The purpose of the law. You just want to prove that this is the law. Then I think every plan, as you are rightly mentioning that we should go back to our plans. Is there any shortcoming in that? Every plan will have some shortcoming, right? So here though we have gone, but yes, coming back to the point, it was a very good plan for the lenders. As a commercial wisdom of COC, I can't raise any doubt. We got a very good value. And despite the ED attachment, this fellow was at least paying money. Otherwise, people would not have paid any money because of the ED attachment. So that is how we gave this undertaking also. That okay, if you are worried on this and if something happens, we'll refund the money. Knowing very well that we don't have to refund. But now that situation came.
No, so it's a very interesting point. You know, this is something which lawyers need to test it and possibly should be taken up before the court. If the same transaction I could have achieved, say, through SARFAESI, through a Section 230 scheme, with compliance of the parameters prescribed therein, a 66% vote, a 75% vote under 230. Over here, I have got everything in place. And now you are undoing the transaction because the court feels some processes have not been complied with. Now, if there is procedural non-compliance, we all know jurisprudence that for procedural non-compliance, you cannot affect the substance or the substratum. So that should have been kept intact. Assuming you wanted to pass strictures, the strictures should be, okay, these are the points. Please be careful with some penalty. Complete the matter. As against doing what they've done.
Year in after.
Year in after. Meaning when I said when going for correct economics,
part of the plan, and this theory of OCs getting much less is again, OCs were getting 50% more than the FCs here, and they got the money. And if they have to refund, I don't know how many of them were surviving. So the OCs also.
Sir, on this point, you both of you raised on that payback, how GSW payback will happen, and now OC payback will happen. Okay, now practically, let's because what we are critically examining today is that this may be turned around. Now, assuming that this is going to stay.
Correct.
Okay, if this is going to be a stay, and we will have to take it with us in the thing. In this case, my reading about this is, what is the order said? Liquidation. What has gone into liquidation? A corporate data. What is his balance sheet? Now undoing of mergers and all doesn't come into play actually. That corporate data, whatever is standing in the liquidation will come. JSW, if he has invested as an equity, he will stand as an equity. If he has given as a debt to that company, it will be a debt. He has to file a claim in liquidation accordingly. He will be taken as for waterfall mechanism. Why are we applying too much of mind in what will happen in this?
Yes, sir.
If it is a liquidation.
No, sir, that's not correct, sir.
That's not correct.
That's not correct.
There is one big issue.
Yes.
JSW has invested other than what he paid to the financial.
Correct.
creditors. Now he has invested a lot of money in expansion. Now how you will take that out? First of all.
So I will tell you that only. So he has put the money in that there are two ways, either debt or equity. Okay, JSW is a separate entity. We have all studied Solomon and Solomon. So these are two entities and it's a business call. Had JSW merged this with him and now it was to be segregated, that was a challenge. It is not merged. It's a separate entity.
My view here is whatever points that have been listed here, about 6 of them, more or less, all of them are curative.
That's right.
You have to find a solution to the problem, not create
That is now
something which is
what we
already
now
created.
So
It's very easy. I mean, Form H, this is what is an administrative document. Similarly, 29A, this can be actually corrected in the form.
But I am trying to focus. Look, this all will be discussed and this is now not in our hands. It is now in the review petition or a cumulative petition, whatever happens.
after review.
But otherwise, there's a
Years of review phase. And we have already seen in Indira Banerjee matter where review failed. It is another case law that came after that case law, which said that now this is a new
Rainbow
judgment. So
curative, review failed.
judgment
fell back on the earlier judgment. Of course, there's an erroneous judgment which we are actually dealing.
But it is a judgment given by the Supreme Court, which is the law of the land.
So-
Unless you change the law or that law becomes the law of the land, you cannot do that.
Absolutely, but all these pointers which have come out, whether it's a review petition or not, most of these are corrective actions.
Correct.
All we can do is, okay, fine, we can't undo the past. But what we can do in the future is just correct those point items. That's what the judgment should have actually captured.
Right. That ought to be, but what it is.
Yeah, but it has been so stringent to destroy the whole process.
To be part of CRP calls.
Yes.
In the time limit.
So, sir, couple of pointers. The judgment says annulment of contract. Please understand, RAs make an offer. That offer is accepted by COC. It is a concluded contract.
Correct.
It
It's only
becomes
stamped by-
it becomes a valid contract under Section 10 the day NCLT approves it, capable of being implemented. The contract has been duly implemented. Now, for reasons which Supreme Court has set out, it has said, I am avoiding the contract. If I'm avoiding the contract, which is the principle of restitution which follows. The principle of restitution means put parties to their position which originally they were.
After 5 years,
That is the problem. That is
What
the
happened?
problem.
it's like somebody who's gone to abort a baby and
So
the baby is 5 years old, and then after you decide
Now you said
can abort it.
put the baby back.
How
That's exactly
possible?
what I said. So basically what they,
Technology, I think no one.
How do you actually apply?
Technology should have been put across, probably. And
Oh.
no, so this is where I said on two grounds for review. One is your 142 itself technically being used as an inherent power to order liquidation, which power technically is not of the Supreme Court, or for that matter, not of anybody's court. The decision to salvage or destroy is purely of the creditor-driven decision. The law is creditor control. The second, yeah, and the second point is hardship. The law cannot throw so much of hardship onto the table. Imagine there are CCDs, there are equity, there are capex which would have been done, there are additional expenses. Now somebody is going to sit down and do accounting for what JSW has actually spent as greenfield, what has been an accrual. It is a nightmare.
You can't undo that.
All of this should be taken up, and we have to move accordingly.
The point is, if let us say all these things don't work,
Then we are in a trouble. This
then
matter
we
is
are-
in.
then what can happen? But I am giving you a simple solution. It's not that difficult.
Liquidation.
I liquidate the company, sell it back to JSW.
Absolutely, but
I mean,
that
but
will still not serve the purpose.
But that's a commercial decision.
It will
Commercial
not,
decision.
it will not serve the
It can even
purpose.
happen that we sit down with JSW as lender.
Sir, that will
sort
again
it
be
out.
challenging because you will have to do through e-auction.
We'll
And
do
that
auction.
time, if someone comes, because now the price is substantial,
Nobody will come.
if someone bids, then how can you compulsion?
All,
Liquidator will
No,
not
sir,
be in
no.
position
Now
to
the problem is-
JSW will bid the highest. We will give everyone to right to match. JSW will match that. See, by the way, it is the same story like nowadays many people invest money as an investor, and then they take the company through IBC, assignment route for
Assignment
take it through ARC and whatever, and then they take the
So
company
all
to
lenders
IBC.
assigned to JSW.
this is like,
And
of course, a backdoor entry of doing
yes.
very well, but why not do it?
There at least
Why do it?
assignment. What I'm saying is,
If
we just go through liquidation.
Why doesn't do it the legit way?
Its market value must be much higher. Suppose 90, technically, if it is at 55,000 crore, 30,000,
What was I saying?
will JSW pay that difference?
कोई पैसे तो उसका ही जाना है ना, उसके पैसे
एक पॉकेट से दूसरे पॉकेट में डाल देगा ना.
उसने पैसे इन्वेस्ट किया है ना already. Suppose today, in any case, you are right. Today value is at least 30,000 crore. 30,000 minimum, because we have already put so much money as JSW, as capex, etc., profit, everything has happened. So in today's time, if you ask me, the value will be minimum 30,000. Minimum. So let us say JSW bids for 30,000. The challenge is, as Snail is saying, that somebody bids at 32,000. So then we will give a right to match to JSW. So they will bid at 32,000. The money goes to them only, no? In any case, it is their company. Lenders are not going to get anything.
50-60,000 तक लेके जाओ.
तो कितने पे भी ले जाओ, उसमें आपके लिए काम आ सकता है टैक्सेशन के लिए, क्योंकि कितना सारा टैक्स देना पड़ेगा अगर उसको within system. I don't know how they will account for it.
So, but that is what one day is looking. But in liquidation, how the process will work is basically section 56 will come into play, waterfall mechanism. और वो बैलेंस शीट किसका आएगा? JSW का आएगा. उसमें रेस का आएगा, सीडी का. JSW का क्या लेना देना, वो तो इन्वेस्टर था. देखो आप IBC निकाल दो. Let's not think this is IBC deal. Let's think this was a deal where JSW took over the corporate data, and tomorrow they have some issue and they want to separate it. It is same way. So why we are so worried? Yes.
These
Even though banks is there,
issues,
it will be there for everyone.
these issues.
Sir, there are so many speculation. I think it is too early for us to
The only
Yeah,
issue.
yes, deliberate on the points.
draw your attention that we have another case law also which is pending to be discussed. So let us finish it first, then after we can open for the quick.
Okay, there is one more challenge if I
एक मिनट सुनते हैं पंकज भाई.
Sir, I have similar some confusions here. First of all, let me appreciate that today we are lucky. We have got our own brother having banking and ARC experience, our own brother having IP experience, and a very sharp legal mind. And now questions are that the court has ordered for the refund. Now suppose if one of the lender is again in either administration or in the CR. So how that can be, because there is going to be moratorium. how they are going to refund the money? They got the money.
We filed.
Claim.
So secondly, second question. Suppose if the liquidation value comes lesser, liquidation offers also comes lesser than the original bid amount. In that scenario, how this will be taken? And third, there are a lot of strictures mentioned against COC, against
RP.
bidder, and against the RP. So what will happen to that?
Second scenario, there's a haircut to JSW.
In spite of having all this, you can still give to JSW.
Restrictions what we are talking about,
You
these
want
are
me to
already
respond?
the disciplinary action which took, no, it is not this case only disciplinary action.
Snell bhai, let them answer.
Want me to respond?
Only.
First question is if some lender is under,
Let's
insolvency.
say New India Bank.
No, it's not there anyway. Fortunately, we don't have news. So it is not there. So that risk is not there. But I don't know, before you came, we will discuss that. There could be some funds which have completed their life and they have already exited. But then those funds have invested, would have invested through some ARC, so that ARC is responsible for it. So they will be able to take care whatever, even if they take it at their loss. They have to, that is their responsibility because they have given undertaking, technical. You can't be just saying, because I gave the undertaking, but I took a counter undertaking from a fund which is not, no more there, so I will not be able to pay. No, that law cannot work like that. So that is the first point. Second point, you said that, what did you say second? Sorry? About liquidation value being less. Technically, and today if you ask me, realistically it is not going to happen. But hypothetically, if it happens, that will be a loss to the financial credit.
Only reason why it can come low also because there are plethora of litigations now.
There are no litigants in this case, by the way.
Might happen now.
No, it can't happen. Unless, see, as a country, we have full of people who advise litigants also, but in this case, at least it cannot happen.
So what in yesterday's economic time it was that NCLT is started with the litigation, they want special bench.
So even Bombay is.
No, Bombay only. Bombay ka wo to.
Somewhere they must be requiring to go somewhere.
He said, I need a special bench only for Bhushan Power and Steel. That is an NCLT member saying that. So that's a different issue. Chairman.
They are expecting a lot of litigation in this.
No, not litigation. He said that if I have to run through this entire process again, whether it is a liquidation or whether it is CIRP again, there was a view, there was a suggestion that let Bhushan Power and Steel go through the CIRP process again instead of liquidation.
So that is the easiest way to do it. It will not kill the company. In fact,
So-
JSW is implementing an expansion project. They'll stop.
Third question is important.
Third question was that there are strictures against COC, RP. I think we discussed that issue. And SRA. See, this is the one, I think I was making a point earlier, who are the people who litigate or who challenge the plan. First time I am seeing Supreme Court has added one more category, the successful resolution applicant itself. Though it happens indirectly in the entire system, thanks to all of us who advise and big firms, legal firms and all that, that SRA keeps on raising some issues here and there to delay the payment. And that happens. In this case also it happened, and partly because of ED attachment, but otherwise also. Because as I mentioned, the steel industry was not doing that well. So they just wanted to delay. But then that delay was factored in. Like even in Binani, we had interest, even in SRC, we had the interest during that period. Like say KSK Mahanadi, if you really see, though it has taken 5 years, company has cash balance of 15,000 crore. See, the only case where I find the delay was to some extent because of different reason, DHFL was one. There was delay there also. Even in our capital, user kept on doing delays and without paying any extra money. So if I am getting as a lender extra money during the delay period, It is the same thing. When we do a settlement as a bank, we charge interest if the person delays. It to some extent it compensates. But if I keep the borrower or the resolution applicant keeps on delaying without even paying any compensation for that. And that is how in this judgment, what we were discussing, that one way could have been that you charge interest for this delay. Supreme Court would have said, okay, you delayed 18 months, you pay interest for that. That could have been instead of just canceling the transaction, which you can't do in commercial law. You can't do in as economic legislation. You charge a penalty. It is like stock market. Can you reverse the stock trade, which has happened? It's very rarely it can happen. Shares have gone in the system, transferred. So you can maybe charge a penalty on the buyer or seller if they have done something wrong.
About the stricture part, what Madam had mentioned, now after 5 years, somebody is giving a judgment. At my age, I'm RP, I may not be there.
No, sir, the law has now been changed. Now the law has been changed. RP is responsible for 3 more years for any penal action after the last case is decided. They have amended that 3 months ago.
So there is one case wherein the RP is expired and the case is running for the last 3 years.
It happens, and they say that we are not passing any order.
And it's
Finally.
early dissolution order.
So what I was coming to is section 33 has a provision for liquidation even after implementation. So this situation, let aside Bhushan Power and Steel, this situation could come practically in any case because 33 provides for liquidation if there is any contravention of plans and aggrieved party goes to NCLT, liquidation is technically possible. So it is good that a discussion on how to liquidate a company after implementation or during implementation has come up. I think we should be able to find some solutions
We
to that.
have filed some cases. We have filed some cases for liquidation after implementation.
Right.
But because those plans are not fully payment has come.
Deferred payment.
There are many deferred payment plans and the guy doesn't pay.
Then it can be
So we have
forfeited and
filed for
taken process.
liquidation.
But in this case, suppose if we keep that option open of compensating for the delay, so everyone will offer upfront amount in the.
And suggest solutions here. We are discussing the case. We cannot suggest solutions because that will not work. And I think all the people involved must have thought about it at that point. In this particular case, as Bansal just said, the capacity has doubled from 1,500 MTPA to 3,500 MTPA, more than doubled. And at present, it is being expanded to 4,500 or more. No dividend has been taken, no payout to JSW. All money lies in whatever has come in into the company only. So the value has
more challenges there. The expansion that they did, expansion is done by.
I'm only talking about liquidation value being higher.
No, here also the practical challenge that will come. Look, one thought as I stood it, but other thing is that the acquisition is done through other companies. And this company is using that company's infra for the expansion. Now that is where the problem lies.
So on a lighter note, I am not able to think about how to liquidate because I am not going to be paid for that. So I am not able to think. So Ms. Host. Anyway, sir. So
anyone thinking on it, just like he is not thinking. Anyone else just like
Sorry.
anyone thinking on the liquidation line?
Liquidation is actually, it's not a solution, ultimately.
You don't require a solution. What is law you want to follow? We are executors.
It is, see, either it is commercial or it is not. If it is commercial, it has to be decision based on practical situations, and every situation is different from the earlier situation. And that decision has to be made by those people.
Anyone sitting here wants to become a liquidator in this case. Let's go that way. And then this, after this, we will take
Sir, I was,
this point.
we will take up. We will take up
liquidation नहीं होगा.
We will take up the MPID.
Law itself will be amended.
Yeah.
MPID.
We will go to the other matter now.
Wait for the change.
No,
of
I'm not saying I itself could be amended, I am saying.
But ultimately, there are too many gaps.
Madam, we move to next case law.
Yes. So
that is also equally important.
So now we have another order passed by the same bench, and that was in the matter of National Spot Exchange Limited, which was a huge fraud which had been unearthed. So in this, the bench has come out and they have framed two questions. The first question that was framed was whether secured creditors would have a priority of interest over the assets attached under PMLA and MPID Act by the virtue of SURFACE and RDB Act. So the first question was limited only to SURFACE and RDB Act and whether secured creditors would have priority of the interest. So that was the first question that was coined. And the second question that was coined was the question regarding IBC. They said whether the properties of judgment debtors, that is the corporate debtor being the judgment debtor, and the garnishes attached under MPID Act. So under MPID Act, there is a provision of garnish attachment in which government would do recovery from the receivables, and the receivable being asset of the CD or monies payable by the CD, etc. So they say that whether it would be available for execution of decrees against the judgment debtor in view of the provision of section 14 of moratorium. So moratorium is going on, and whether in such a case the assets can be recovered by the MPID authorities of the state government. So first question doesn't talk about IBC. Second question talks about section 14 and IBC. So let us see what the answer is there in the judgment for the IBC question. They say that it is held that the properties of the judgment debtor and garnish attached under the provisions of MPID Act would be available. They say it would be available for execution of the decrees against judgment debtors despite the provisions of moratorium under section 14. So even if you have section 14 in place, if there are assets attached of the corporate debtor, it will be available for recovery and attachment to the particular state MPID Act. Now they are not talking about 32A here. We will have to apply our mind whether attachment will be complete recovery or not. We will have to discuss that, because in SURFACE they say very clear cut, we will go to that the MPID authorities will have priority over the secured creditors. So that is very damaging. If the same analogy is applied in IBC also, then cases like PAN card club or DS Kulkarni or others, where a lot of depositors were there, where MPID Act, which is a Maharashtra based act, but there are many other acts all over the country of the states. So they would be there. So I will go back to the answer in question 1 now. They have said very clearly here that merely because SURFACE and RDB, which are enacted in respect of subject matter falling in list 1 of and having been enacted by Parliament, they could not be permitted to override MPID Act. They said overriding will not be allowed, which is validly enacted for the subject matters falling on list 2, that is the state list. If such an interpretation is permitted to be made, it would amount to denuding the state of its legislative power to enact and enforce legislation which is within the exclusive domain of the state, and it would offend the very principle of federal structure as set out in Article 246. And they also say that section 26E could not be said to have been attracted to the facts of the case. So they are doing away the power of 26E in this particular case. And they are saying further that it is held that no priority of interest can be claimed by the secured creditors against the properties attached under MPID Act, and the provisions of MPID Act would override any claim of priority of interest by secured creditors in respect of properties which have been attached under MPID Act. Very clear-cut judgment, talking about 26C, talking about garnishee recovery, and I read it a couple of days ago. I still have not been able to digest what is this going to do. On one side, the situation of IBC and Bhushan Power and Steel we are seeing. On the sidelines, we are also seeing that the two alternatives that lenders had, SURFACE and RDB, are also being hit. So it's like if I have a hammer, I see everything as a nail and I start hitting the nails and I start hitting, but everything is not the nail. So you can't deal everything with a hammer. So I will stop with that. I would request the panelists to put up their views and then others also can contribute.
I'm not expert in that area, but I would only say a few things. And as I mentioned earlier, there are different statutory authorities which have started raising claims unnecessarily. Some judgments which have already created problem like say Rainbow or Jet Airways. Now, there is a new thing. Somehow, I think these two judgments, Bhushan and this one, and as I mentioned earlier, the earlier two judgment also came from one judge, and this they seem to be dead against the banking system, looks like to me. If you ask me in a lighter vein, I should stop lending as a banker. If this is, and just count the things, gratuity, PF, Jet Airways, Vidarbha, because tomorrow, due to any reason, my IBC will not get admitted because somebody will say I'm viable. Anyway, I'm solvent. Then now you have Ocean Power and Steel. If I have to refund the money after 5 years also, then where is the certainty to recover even the money? Then you have, okay. So serious note, we have seen this misuse of this law in Bank of Maharashtra case. So I'm more worried on central laws being misused for voter lobby. Not on this judgment. I'm more worried on the other side. The same DSK you mentioned. In fact, if I tell you the truth, Bank of Maharashtra gave loan to repay the deposit. Okay. So to help the depositors, we as bankers and even IDBI was a party to that. We gave money to the company that okay, this guy should not default to the deposit. And same bank, the MD going to yoga on a cycle is arrested in the morning, and the ED is arrested. The earlier retired MD is arrested. With the stupid police, they had no power. They had no power to arrest. And after that, there was a big issue in IBA level and all that. We had to get the law amended and clarified that police has no power to arrest the bankers. But damage was already done. And why it was done? Just because of some so-called depositor in Pune and voter lobby of Maharashtra. Sorry, and even if some Maharashtrians are there, don't mind. I'm just saying for voter lobby, you can go to any extent. And I'm worried that on this type of state law can be really misused. And this judgment is in fact, last nail, I would say, in your court. You were using the nail analogy, at least in Maharashtra. And same thing has happened with us in a political case also. There was an FIR against us because one guy where we filed a case NCLT, he claims that he committed suicide because of that. Right? And this was again political. So the state law, if this judgment comes, so if Surfaci and IBC, now this is one region, then there is already conflicting judgments on secured lender versus unsecured lender. Who is the secured lender? Now, there are judgments in IBC by some courts that secured and unsecured will get the same amount. Right? That has not been clarified by Supreme Court even now, despite we thought Section 30 was very clear. And then law implementation committee initially also, this was point raised at that point of time also. But the cases are still pending. In Supreme Court, they have not clarified that. So if I really look as a lender, there are a lot of negativity coming. And today it has become a fashionable, frankly speaking, to hit the bankers. Because see, first round, the government of India was worried about that they have to give money to the banks. So they were very keen to resolve the cases through IBC. They were very supportive. Today they are also not supporting the banks in that sense because अभी उनको इतना कोई cases देना नहीं है ना इनको equity देनी है बैंक को. स्टेज तो चली गई है उनको. So they are also in fact indirectly encouraging their own departments to file all these cases through PF, through gratuity and through taxation. Though after even passing the law that statutory dues are junior. So because they don't have to give equity now to the banking system, so they are also least bothered about IBC, frankly speaking. So that is why you find Government of India is not very keenly doing anything in the support of IBC. So that way, this IBC is not going to work the way it is today. It has become another BIFR today, if you really ask me. So you have to have another round of NPA creation by the banking industry, which anyway they have started lending now, but that will take another 3-4 years to at least get those accounts created, and people like our development bank, like IDBI, they used to do. So now we have started doing that.
Sir, why do you wait till NPA? Default pay karo na. IBC will come into play if you start at default level using our services.
तो डिफॉल्ट पे ही है अभी भी.
तो फर्स्ट डिफॉल्ट SMA 1
IBC में कहाँ लिखा हुआ है?
NPA
NPA में IBC में लिखा हुआ है डिफॉल्ट पे है.
आप NPA के 3 साल हो गए ना. जब किया तो डिफॉल्ट तो तुरंत होने वाला है.
डिफॉल्ट करने के लिए टाइम चाहिए.
3 साल क्यों रख रहे हो?
Anyway, sorry, I am just saying it's a bad law. I mean, bad judgment in that sense. So especially at the state level, keeping in view the politics involved at the state level. So the second point which judgment says that in IBC, I think that is okay. They are talking of
That's
if
a corollary.
something has already been
That's a
attached,
corollary, yeah.
that is okay. But if something has not been attached, that cannot be done, right?
They say that.
It's the same PMLA thing.
They are saying during moratorium attachment can happen. After CIRP, this attachment is allowed.
Sir, I'll just.
Then what remains?
Sir, I'll just.
I think Ajay will.
Sir,
add
I'll just
better.
legally.
I have
dissect
more of commercially, frankly speaking, sorry. No legal knowledge to me, so I'm.
No, I'll just legally dissect this. As far as PMLA is concerned, it is a central enactment. IBC is a central enactment. The law on PMLA versus IBC is very clear. At least jurisprudence is clear that 32A comes into the picture once the asset is acquired, so asset cannot be taken back as attachment, etc. But during the pendency, if there is a ED attachment, then whoever bids for it, bids it with an open eye. Then there is no, the Delhi High Court judgment is very clear. All number of petitions are all added up to Supreme Court. As we speak, the law is that PMLA versus IBC, both can be construed harmoniously, not against one another. Once the resolution plan is approved and there is no attachment, there cannot be subsequent attachment. So prior to the resolution plan being approved, if there is an attachment, then the person who is buying he's buying with that risk. Now we come to MPID. MPID firstly is one of those archaic laws in today's situation. Meaning, I don't know why why the Supreme Court has to waste so much of time. I've got nothing against depositors. Please don't, it's not like I only represent corporates, but at the end of the day, there are various other means to address those situations. MPID is similar to what is called the State Financial Corporation Act, SFCs. Now, if SFCs also had a non-obstante clause, right at the start, Ronington Nariman in various judgments clearly said, because I believe that people are going to start using the non-obstante year, go and register under the SFC, which is similar to BIFR, because the argument which was being used is since BIFR is annulled by IBC, SFC still survive. And SFC also has a similar provision to Section 22 of SICA, which means that you can just go and park your vehicle in free parking.
Surprisingly, SFC Act has a section called Section 29.
Akin to Section 22.
Section 29, which gave them power to sell anything.
So basically, this came into the picture. Luckily, the courts clearly said you cannot use SFC to undermine IBC. That law is settled. Now, this animal called MPID, what they have distinguished, where it hurts most is not IBC. Honestly, I don't think this MPID Act, I would be too concerned with this judgment on IBC. The biggest concern is you have 26E under SURFACE, 31B under the DRT. What it does, it brings about what is called priority in claims. Priority in claims for all stakeholders. The nomenclature there, and if we look at the provision, it is specifically, it doesn't matter, operational, financial, government, taxes, cesses, everything. English language has been misused in this particular judgment, where they have said, you know what, the claim of the depositors which have been basically aggrieved is an act which is fraudulent committed by the corporate debtor, is not a debt. So therefore, it is not subject to the priority as enunciated under 26E or 31B. So they have stuck to the very core for which this legislation was passed by the central government. Now, what is critical is possibly the central government, when there is a conflict between a state law and a union law, technically union law prevails, but there is a doctrine in law which is called pith and substance. Now, this is very, very legal. Now, pith and substance is going to the pith and the substance of the legislation to check its archaicness. This matter has to be really argued in the review petition to clearly say that MPID was subservient, is subservient, and honestly, the relevance itself is questionable. And if that be the case, that cannot throw an existing legislative framework with intended, which is far larger, purposive, to be subservient to an enactment of this sort. So the second question about 14 actually is an offshoot of this first one. So if the first one itself is decided in the negative, then the second one is not relevant, because if it is decided that this particular act prevails or can be harmoniously constructed, then section 14, just like PMLA attachment doesn't get hit by 14, this will also not get. But it is very critical that this MPID, and I'm sure Depositors Act, state legislation are there in various enactments. And as sir rightly pointed out, it is a electoral law rather than a legal law. It's purely an electoral law.
We have seen this happening earlier in chit funds. We have seen this happening in RNBC. So public also should understand that. So they should not give any deposit. Anyway, Companies Act itself provides very clearly perhaps to discourage the depositors, right? It protects otherwise depositors.
That's right.
Central Act.
Yes.
Now, as a lender, we will start taking two precautions. One, if any guy has a deposit, especially in Maharashtra, I will not give any loan to that company. Second, I will not give NOC in future to any guy who wants to raise deposits. I'm just saying practical solution. So in Maharashtra, especially, if anybody has raised deposits, then as a lender should be very cautious in giving money to this.
Ajay,
yes, sir.
Question to you on this point only, MPID and SURFACE, what we are talking. And as you said that SURFACE now this challenge has come and that needs to be taken
addressed. Yeah.
But in SURFACE, what I understand it has not come out in this case law. There is a database that came up in SURFACE,
SURFACE, that's right.
Okay, because when Rainbow came, again, that point was raised, I had raised out of that points at that time also. SURFACE is the MPID attaches your immovable properties. And SURFACE registration is required for any decree, order, or anything. If it is there, if it is in SURFACE, then they can do. So if MPID decree or something is there, if it is not there in SURFACE, then they cannot have what they are claiming in this case. They cannot have an upper hand on the secured creditor. Because that is the law settled, and that is a central law which is given these rights to them. And because of this, that SURFACE has been given that importance. So this point has never come up in this case law, whereby they are giving, because all secured financial creditors would have registered under SURFACE.
So what has happened is that as far as IBC is concerned, it is a pure economic legislation. I think people should, again, all the judges also should read the preface again. It is not a social legislation. What they have done with this, a social legislation has been used to override an economic legislation using a legal technicality. That itself is flawed.
So my only point was like this SURFACE, because in Rainbow also, this was the point that GST authority started sending. But if GST order decree has not been registered with SURFACE, they never had a.
Agreed, but that is the law today also. Today, yes. Irrespective of MPID.
But this is not being looked at, because on this point, SURFACE is where major people are not aware.
So that's very important. People should register with SURFACE.
Has to come, and this SURFACE has to in this case also, this has to be brought out later on if someone is asking.
But if she has ignored SARFAESI itself
That's
while passing the judgment, she will ignore SARFAESI also, no?
Exercise तो बाद में आएगा.
Both are central acts, no?
Sir, any queries on both? We can start with NCID first. Any queries that come to your mind, you may please ask, because this is a recent judgment, we are still studying it.
So who has to file review here?
So creditors should file.
The suffering part.
And I am asking who is the affected party here?
The secured creditors who
Yeah, sure. There are no secured creditor here. This is the NSE saga. If you really see who is secured, who is unsecured.
So, but law में किसी और को change कर दिया. Intention को
So
कुछ और.
government has to file actually review here.
इसमें state law versus sectoral law हो गया.
That's what I am saying. So who will
Or
file review?
individual versus public.
Sir, IBBI को लिखिए आप लोग to file it. Honestly, if you ask me, IBBI had come up with a notification in between to clearly say that wherever we believe
Has
that
IBBI
has to-
filed any review petition up to now?
Sir,
They
reality,
don't bloody
they don't
become party
intervene.
also.
Sir,
They
don't
even
intervene.
stand.
Sir, intervene नहीं करते हैं.
They
But आप
don't
तो
even
intervene.
even in Rainbow.
Sir, intervene. Sir,
Even in Vidarbha, they should have
intervened. They did not support.
But they say that when you call to the IBA number officially, sir, there is a, amendment is going to come, to see that what can be done.
Sir, amendment.
When you call, you are very lucky guy. हमारा तो फोन ही नहीं उठाता.
मतलब success 10 में से एक
Sir, एक rate file कीजिए IBBI के खिलाफ to act upon the.
कोई ये पे नहीं देगा मेरा.
अच्छा, you all are directly reporting to. Sir,
So the key point in this, no, is state versus central law.
Yeah.
They have said that state law will have a precedence over because what you say.
by English language
substance.
interpretation saying that it is not a debt, but anything is a debt.
And individual versus public, because these state laws are for public. It is like home buyers. How home buyers came into play, which was not a part of the thing, and later on. So individual versus public.
But this is interesting.
This is an interesting judgment, and even
Till now in real estate also under RERA, whenever we talk about the companies under CRP, they used to keep the proceeding in place.
Abhens, yeah.
But now with this, I think they will proceed. They will
Parallel.
also issue the recovery warrant. Then collector will.
In fact, all state laws will start, whichever state, like.
Non-obstante clause of any other statute. Ronington Nariman, when he passed the innovative judgment, if you look at the detailing with which he's gone, till he was there, one thing was very clear, he was always landing IBC to a safe zone. And he was landing it to the extent that articulating problems, addressing those problems, not even articulated by lawyers.
That's how the law actually found its
That's right. We had a jurist. We don't have jurists anymore as judges. That's the problem.
Okay, Ajay, just tell me something. The first case law, wasn't there something like JSW had invested via equity and debt?
That's a minor issue. In fact, it has been blown by the CNBCs of the world who don't read the judgment. They spoke about equity and everybody is latched on without reading the judgment. On equity and CCDs, it doesn't matter. It is equity. CCDs is equity. It is not OCD.
Even if it is CCD, end of the day, whether it's CCD.
Their investment in a passive.
Yeah, absolutely. The investment can come in whatever form.
Money has come in.
So that is not even a point, honestly.
So what's the question in this particular order?
They have said that everything was equity. Why did you do CCD and equity? To which Abhishek Manu Singhvi responded which is recorded in the order, to say that because of the uncertainty, they kept the debt angle. Problem is by making that statement, all this adds up to the reversal.
Then see, ultimately, of course, whatever advocate speaks.
That's what I'm saying. So sometimes, what happens is most lawyers, sorry, at the stake of criticizing my own self, most lawyers today, we are trained for interim reliefs. We are not trained for final reliefs. So you give a lawyer a mandate, he is more than happy to take up an interim relief matter, but you tell a lawyer today to argue a final matter.
The situation because of the high courts.
Everywhere.
Every other court gives only.
Everywhere. So sometimes, when we are briefing counsels, I just don't have the patience to be in court. But sometimes when I'm briefing, I am just so tempted that possibly if I argue, I will argue it much better.
No, that is something correct, because I have also experienced in some cases, some seniors, they will look at the whole matter one day at a time. even if they may have a through and through, I would say, clarity in their own mind, that won't be shared. And then they take one relief at a time and proceed. That succeeds many a times, but in that you may end up committing some things which can stick to your neck, and you can't just take it out. It becomes an albatross.
Whatever, it's all said and done. Do not mind. Most cases, it's just the advocates just to take another date. They park things and then they go to the next round. And then it is the next, because the IP, poor thing, first of all, they don't have money for themselves. They have to pay the council whether they pay the AOR or no.
Sir, in MPID, deposit is defined very loosely. This deposit is defined very loosely in MPID Act. They say any money given to any person or organization. Madam, एक minute, no cross talk. They say deposit is any money given to any organization, person, etc., with an expectation of return or fraud. That is how loosely it is defined. So even if you have unsecured loan lying in your account, that person can go into MPID.
Even in case of Mumbai, जहाँ पे investment agreement enter किया हुआ है,
Yes, that person will become a depositor, yes.
most of the cases,
Real estate, to save themselves from RERA, many a times they take money as an investor first, and then when they get the permissions, they convert that.
so बहुत सारे cases real estate
MPID में एंगल आ जाएगा.
CIP cost has to be done free. There will be MPID specialists now.
I think it's heavy now.
Now we can conclude now, I think. Any questions?
Specific question, otherwise.
No, I want to, it's not a question, it's an observation. Observation. So one of the stricture Supreme Court has passed is against NCLT, that you were not authorized to do something and you are doing it. But in real life, practical situation was that so many things were happening which was not allowed under IBC. The IBC is supposed to be overriding all other acts if it is not inconsistent with other. So we have seen RP got arrested, he was jailed for a night. So wherever we had an issues, we used to rush to NCLT and NCLT. Bhai bachao. But now, after this assessment, we can't do that. So what will happen, suppose police take some action which is they are not supposed to take? Will you go to NCLT, NCLT, or you will go to police authorities? So in ED case, it's very clear that you have to go to appellate authorities which will take its own sweet time. So we are in a very tough situation. But similarly, like ED, there will be so many other situations. Maybe custom office will create some issues.
Provident fund have the direct.
Don't forget the factory access.
Factory Act. So in all those situations, earlier we used to rush to NCLT and NCLT and use.
So by doing all of this, what they have done, if you look at IBC preface, they say that it is a legislation to consolidate.
Yes.
What they have done is they dispersed everything now. So somebody should really, in the review, I think sir pointed out, the central government should now intervene, or Ministry of Finance, because it impacts all bankers. This particular enactment will change the gameplay, though it is not intended for this matter, but it will change the law.
One more thing.
You mentioned last that there's going to be some change in the enactment of the law going forward. So, I mean, yeah. What do you suggest?
One more thing.
For revenues?
Nothing else. Not want to have that negativity. Liquidation का बात करना नहीं था, इसलिए उन्होंने बोला law change.
One more thing.
छोड़िए sir,
Earlier in the.
पैसा जो आता है during CIRP and post CIRP. Post CIRP is now going to be decided upon. What happens during CIRP? Something is earned. Who does it belong to?
The money that comes during CIRP is of the corporate debtor only. If there is any loss.
I mean, CD.
If there is loss, that loss is also CD.
Later on, it depends on what is the matter, what is written in the plan.
Now, plan may want to have both situations.
Lenders have to be
That is the clever mix.
duty of the COC member.
Because
They
already.
made that mistake in some cases. Now they are smart.
Sir, in number of instances, they have forgotten to write that this belongs to them.
Thankfully, at least in case ke Mahanadi, they had written. Otherwise, the amount is 13,000 crore.
During CIRP.
Yes, 5 साल हो गया उसे यार.
Because otherwise by virtue of law.
नहीं आता कि कितना time लग गया है.
SK
Mahanadi.
SK Mahanandi.
Same.
If you do not write, then it belongs to the CD, so it will belong to RA.
One more thing,
Exactly, this is what it would
one
interpreted as.
one more thing, now in the resolution plan approval order also, we used to claim lot of waivers and exemptions and all that. So NCLT has started writing after this order, you go to the relevant authority.
Yes,
Now,
absolutely.
relevant authorities, there is no provision like.
But after this order, sir.
ये पहले से लिख रहा है. ये पहले से.
Last 5 years.
Last 5 years, but particularly something was given. Now, so after this order, everywhere you go to the respective authorities.
Sorry to interrupt. NCLT didn't agree to what JSW wanted. That is why JSW had to go to NCLAT. And the Supreme Court is saying NCLAT also had no power. So what you did. But then if you put so many conditions in the plan, which NCLT, let us say, had no power and NCLT is not a. But then that is also impractical to implement a plan. Same is the case for like say Reliance Capital. So Indies also raised the issue that unless you allow me, I need to RBI approval, I need IRDA approval. How do I implement the plan otherwise? So there are some, I would say, practical issues which needs to be approved or delayed, whatever reason you can say. So similarly in JSW, there was an attachment also. And there were a lot of other issues. Some people will misuse by, quoting some issues here and just to delay the thing. But otherwise, some approvals are required also. Let's say a electric connection or something is required. If PF authority keep on troubling, then you need something at least from them. You need the company's registration in MCA portal or whatever. I don't know. I'm just raising some
Sir,
issues.
एक judgment positive आया है, where all the statutory authorities and implementation of a plan, electricity dues is settled at 0. They were not listening, they were not giving connection. So somebody filed a contempt petition. So a bunch of matters got tagged on by the Supreme Court, and the Supreme Court said, referring to Ghanshyam Mishra, that if you do not, then I'll be curtailed next time. So they have actually, that one was a positive, one of the positive judgment amongst all the.
Maybe there practically it will never be implemented. I can tell you that.
Petition file
MIDC नहीं मानता electricity.
It will never be implemented.
But writ petition file करना पड़ता है तब.
Not only the bankers, the resolution applicants has also to think whether I am buying through IBC, whether it will be, I will get a clean slate, okay, return clean slate, but if I.
Noida authority is a classical example. Despite Supreme Court judgment about interest or final interest, they never implemented it.
Correct.
And they are not even operational creditors. They claim ये land मेरी है. आप कुछ कर ही नहीं सकते उसके ऊपर.
Same here, MIDC does the same thing.
MIDC में थोड़ा फर्क है as compared to Noida authority.
Ajay, I have a specific question on this law of MPID, what they say in the case that attachment by MPID. I'm talking pre-IBC, attachment is done. In IBC, the company is now come. That asset which has been attached does what I read and I felt is, then that asset does not belong to CD, it is vested with them. So it is not a estate of CD only.
That's
if
right.
The MPID attachment is that.
That's right.
Okay, so the custody and control which RP needs to take, he cannot take custody and control of these assets at all.
Cannot better.
But then if it is secured to the lender already prior to.
That is what the.
Then also. Then also. That is the one thing I was just trying to say. Everybody is.
What is the, suppose I give a.
Punch the lender nowadays.
Securing myself, then somebody comes and takes away that property.
Sir, this judgment says that only.
This judgment is, this is one key aspect which is there where from RP perspective, we are supposed to take custody and control.
Correct.
We are not to take custody and control if the MPID attachment is there. That is one side, that one activity passed
आपका
on
काम
where
कम हो
MPID
जाए.
case है.
आपका एक काम कम हो जाए.
नहीं ना सर, हमको MPID में फाइल करने को बोलोगे आप.
Remove करने के लिए.
अपरूव करने को बोलोगे. पहले लेवल पे फाइल करो, वो उसका ऑफिसर बैठता है अपीलेट में. वो उसके फेवर में आएगा. That second appellate authority will be someone neutral where you can say that something.
And respective authorities will never give favorable judgment to us.
The challenge that will come is MPID, because in one of our matter we had faced, not this case has come now, but in past also we, MPID attaches only immovable. What about movable inside? They don't allow you to take an inventory of the movable also. और immovable है तो guards भी नहीं रखते और अपने guards रखेंगे तो बोलेगा मेरे यहाँ रखने का नहीं दूंगा. Now they have a attachment on immovable. They have movables are there inside that premises. They don't allow you to take that. They don't allow you to put a guard. We have to put a guard भाई दूर से देखना कोई निकाल के नहीं ले जाए. That is only for the purpose of our working.
I will just add one thing
Technically,
here.
this is another
In
challenge.
MPID, all the assets of the corporate debtor cannot be attached. The assets created of the deposits can be attached. So that is the only small that I can see wherein we can go and fight that the deposits flow came into a particular manner, went to a particular way, and that is how it is. That is the only possibility we have to fight. Otherwise, there is no possibility. RP only, sir. RP
It
only.
becomes
sir.
a legal matter. It is the same like proceeds of crime in.
Yes, yes, same.
Thankfully, I can give you one positive note that PMLA ED has started at least giving assets back to the lenders in many cases. We got it in Kingfisher, we got recently in PSL also. Otherwise, they had attached. Even in Bhushan, they gave it back. So I think some sense has prevailed somewhere that by attaching these assets, what are you doing? You are just hitting the lenders only, no? And delaying the whole thing. आप promoter और borrower के against में तो कुछ करना है वो आप कर ही रहे हो in any case.
They have even started giving that asset right to sell by the RP or liquidator and put that money in escrow till the decision is taken. That also
happened in
some cases they have
PSL.
done.
I waited for 3 years in one of our cases. But finally they have at least released that now. After sale also. Otherwise the decision is you sell it, but you keep the money here. मुझे क्या फायदा है भाई तेरा इधर पैसा रख के.
अजय मेरे को एक आंसर चाहिए जो मैंने क्वेश्चन रेज किया ना एमपीआईडी का अटैचमेंट जो हमारे केस में हुआ था उसमें आपको ये कहा था आई वाज टोल्ड दैट इमूवेबल होता है वो इमूवेबल पे होता है मूवेबल पे मेरे को कहीं नहीं मिला था एक्चुअली is it that way that only immovables will be
देखना
attached?
पड़ेगा मतलब just technically है.
No, sir. So far as I have read, MPID they can attach only those properties which are like proceeds of crime in PMLA. Only those assets can be attached. They cannot do a blanket attachment, but in their own order, they write that they have a suspicion that assets have been created out of this. If they can attach 1 crore of worth of assets for a deposit of 10 lakhs, also saying that this 1 crore is created out of this 10 lakhs. So it becomes our headache.
My question is that
all assets
or immobile and immobile something is
all means any assets.
Cash and matter, case Kulkarni, MPID in fact attached all the cars and they sold the cars also. So movable is basically possible to be attached under MPID.
So Ashish is my colleague. So we were the advisor on the DS Kulkarni matter.
No, in one of my case, there was a claim from customs. Machinery was lying in customs. When I took the charge, I pasted a notice there. I admitted their claim. And during moratorium, machinery worth 8.5 crores was sold by customs for 10,81,000 without my knowledge. I filed NCLT simply stated that since the machinery is already sold, just return back the money to CD 10,81,000. And as an RP, they told me that you submit all this information to Central Vigilance Commission Delhi for the further investigation because it is a grave consequence that machinery worth 8.5 crores is sold for just 10,81,000.
So whenever they will start their inquiry in 3-4 years, you can go and.
No, now it has started now.
So that will happen for next 5-6 years.
And then you will have to go to Delhi on your own pocket expenses.
But in reality, the asset, then reality the asset value may be 10 lakh only also.
Yes.
Why you are not looking at that possibility?
No, but that order.
That 8.5 crore can be just fake.
That can be fake. That is what he's saying.
No, but even though in spite of the NCLT order, this custom authorities 2 years to refund that 10 lakh.
Well, lucky.
No, I got that because while filing the compliance, some amount was payable to customs, and I was to receive something from customs, so I claimed for set off. That's why I got the money.
By the way, in one case, why I am raising that issue, sir? In one matter, the plant is supposed to be valued at some 800 crores rupees. It has not been opened as yet, it was lying somewhere. So when we started trying to sell it, the bid which we have got, the valuation which we got was about 5 crores. So it can really, the two, three things can happen also. The technology might have changed completely. Okay, and today there is no value of that machinery, plant and machinery.
I did one textile units here. So there are exhibitions that happens, right? In exhibition, that pieces come. Now, actual the thing costing is, for example, 50 crores, and that sample piece which comes for the exhibition in India is given back and sold at a throwaway price at 5 crores. But that is a sample piece where COD has not happened. Now, there was a unit which was what Sir said, petty pack machines. 50 crores plus वैल्यू मशीनरी का था, बट उसने तो लिया था वो 2 करोड़ में लिया था. अभी वो पैटी पैके करके वो उसने 50 करोड़ का फंडिंग कर दिया, आरपी ने 50 करोड़ का वो वेरीफाई कर दिया, वैल्यूअर ने 50 करोड़ का डाल दिया. प्रॉपर मशीनरी, प्रॉपर कंपनी, everything proper, but you cannot start that machine only because it was a sample piece which was bought here, where some eminent parts are not there.
So it depends.
And it is not a,
we don't know the real
में से चोरी हो गया था.
And in the same case, when I filed IA with customs, that customs has shifted that machinery to Central Warehousing Corporation. उन इनसे खुलवे, उन्होंने 929 days के बाद में 5 करोड़ का क्लेम डाला. After the approval of the resolution plan, NCLT approved it. और amount was to be paid to the operational creditors was fixed. तो NCLT ने क्या लिखा उसमें कि amount same रखो, उनका 5 करोड़ का क्लेम एडमिट करो and distribute it to among the all creditors in the proportion. So जिसने क्लेम टाइम पे फाइल किया था, they lost money. 5 करोड़ का क्लेम after approval of the resolution plan by COC was admitted.
We would conclude now. I will just throw light on two things. In the matter of Bhushan Power and Steel, Article 142 was used to make complete justice. In MPID matters, bench said I am not using 142 because it is not needed here. It is not needed to do complete justice in this matter. So they have tried to differentiate the justification for using 142 in both the cases in 2 days.
And same
judge. Same.
And in one matter, they written pages after pages on 142.
Here also pages after pages. As to how it is not required.
Pages after pages.
Sir, 5 pages are there on how 142 is not applicable in this case of AD. So that is one thing. And then also another legal maxim that they have used is the fait accompli. That is, accomplished thing will not apply. So there is an exactly opposite maxim to that. That is fait justia root column. That do what is right, let the heavens fall. So that is maxim that has been used in the first one. So with that short note, I will request the vote of thanks to be now proposed.
Yeah.
I will request Hemant sir to.
On behalf of WRC, as you know that the main purpose of the study group is to generate the interaction among the members, all the peers. And shortly today's speaker, we have definitely, 3 pillars of, I can say, bankers, as well as IP and legal on the other side. So definitely, enlighten us on the subject. And all of us have already, it has generated a lot of discussion among us. So on behalf of WIC, I propose a heartiest vote of thanks to the speakers of today. And thank you very much, sir.
Thanks a lot.
अभी में मैथ्स मेरे बहुत है तो नीरज और सत्यन से मैं बात
सेंट्रल